Day after tomorrow again there is a vacation call. You follow the procedure.
May I please, Lordship, I beg to mention unlisted bail application, Lordship, prayer for withdrawal, Lordship.
You have to also follow the procedure.
Withdrawal, Lordship.
No, but there is a procedure how to get.
Otherwise, my bail petition is certificate submitted, Lordship.
But you have to follow the procedure. Till yesterday 12 p.m. there was time to send email.
Please, Your Lordship. I beg to mention item number 55, Your Lordship, for withdrawal, Your Lordship.
Item number?
55, Your Lordship.
Yes. What is your item number 55? You are not pressing it.
Your Lordship.
You are not pressing it.
No, Your Lordship. I have actually paid for withdrawal, Your Lordship, but it comes under bail hearing, Your Lordship. Yesterday I have mentioned it for withdrawal, Your Lordship.
Okay.
I'm a new English counsel in this case, Your Lordship.
Heard Ms. G. Bora, learned counsel for the petitioner, who submits that she has been instructed by the petitioner to withdraw the instant anticipatory bail application. Mr. Bashu, you have anything to say? Also, Mr. K. Bashu, who does not have any objection to the said prayer. Hence, this bail application, anticipatory bail application is dismissed on withdrawal.
To mention unlisted matter, Your Lordship, I had sent an email yesterday, but the matter has not been listed yet
What matter?
for the withdrawal of a bail petition.
Why it is not listed?
Send the email, but 2 times we send the email, but the matter has not been listed yet.
Okay, at 2.
If possible, Your Lordship, can it be listed today on the production list for the withdrawal?
Okay.
Make legal Lordship. My Lord, here, my Lord, the affair is at page 13, my Lord. Typed copy. CTP session. Here, my Lord, case diary was called for earlier, my Lord.
But CD not received, my Lord.
But my Lord, I have a submission, my Lord, with Lordship's kind permission, my Lord.
Yes.
Page 13 is the affair, my Lord.
Yes, what is the submission?
My submission is that, my Lord, Lordship, here there are 2 different, my Lord, arrest timing, my Lord. Lordship may kindly turn to page 19.
No, but to appreciate anything, we will require case diary.
Yes, case diary, only on, of course, it is by the learned session judge, my Lord. But learned session judge granted bail because there were 2 different timings of arrest, my Lord. One in the seizure list and one in the, my Lord, for arrest number. There is a forwarding report, my Lord. The date and time at page 19. Here it is, my Lord. 19/6/2020.
Which page?
Page 19, 19.
No, what you want to?
Here, my Lord, yes, my the date and time of arrest.
Yes, page 19.
There is a call, up, my Lord, the date and time of arrest.
Yes.
Date and time of arrest, my Lord, 19/6/2026.
Yes.
And my Lord, at 3 p.m. Now, Lordship may kindly turn to page 24, my Lord, the seizure list.
Yes.
Here, my Lord, it is written, my Lord, the 10:40 a.m., my Lord.
Yes, what you want to say?
Yes, my Lord, and my Lord, only on that ground, my Lord, the 2 accused, my Lord, arrested on the same date under the same forwarding report has been granted bail, my Lord. That order, my Lord, we have obtained a certified copy.
Then why you didn't go?
Because our bail was once rejected, my Lord, by the learned, not by the section judge, my Lord.
No, what is the ground for grant of bail?
No, because
No,
co-accused has been granted bail under the same forwarding report.
No, I'm not getting on you. There is difference of time of arrest.
Yes, my lord.
How it matters?
Yeah, but my lord, Lordship may kindly see, my lord, because there are two different times of arrest, my lord.
No, one is seizure list, another is
No, no,
arrest
friend.
memo.
Lordship knows, my lord, the seizure is done before arrest, my lord. Cannot be after arrest, my lord.
It can be after arrest also.
But my lord,
Seizure can also be after arrest.
but my here on the spot they were it was seized. Then they were taken to police custody. And if Lordship
Case diary.
if reads the the order of the learned session judge, my lord, once, my lord. The first portion is the facts, my lord. The last pages are described, my lord.
What you want to point out?
My lord, there's a page number, my lord. It's page number to likhana hai yaar.
Whether case diary was called for in this case?
According to the in
Even
the
case diary,
last
case diary has
page.
been called for. When can you produce the case diary?
Very short. But here, bail was granted because of this.
You are unable to show anything. You are unable to submit anything clearly.
Lordship, if Lordship reads this order, my lord.
Which order? Which portion?
My lord, this my lord, last, my lord.
No, that I am asking you repeatedly what you want to emphasize.
My lord, that difference of that, my lord, arrest memo in the forwarding report and arrest memo in the seizure list, my lord. On that ground, my lord, bail was granted.
I'm not understanding how seizure list can be arrest memo. Seizure list indicate time of seizure only.
Yes, my lord.
Arrest memo indicates time of arrest.
Yes, my lord.
What you want to emphasize?
But learned court, my lord, emphasized that, my lord, there were two different timings, my lord.
So what? You have to make your submission.
So, my lord, it was two different timings, my lord, and it was the arrest was done, my lord.
Third Mr. S.M. Abdullah, C. Learned Counsel for the petitioner. Also, Mr. K. Bashar, Learned Relational Public Prosecutor, who seeks some more time for production of the case diary. Prayer is allowed. Let this matter be listed when 13th for case diary.
Oblige, your lord.
Wait, please, Lordship. It was a second bail application. Date of arrest is 9/5/2026. As on today, Lordship, 59 days. Statutory period is 60 days. Lordship, I will find the FIR at page 25. Type copy, Lordship.
Case diary was called for on.
Yes, there was called for, Lordship. and
What is the
reject-
offense?
Lordship, offense is theft, Lordship. 305C and 123 intoxication. The allegation in the FIR, my lord, is that the
Why it was rejected by the
rejection order, your lordship will find at page 37. And the relevant portion is at page 39. That there is sufficient incriminating material.
37 rejection order
Lordship,
is by some other court.
Lordship. There is a office note, Lordship. Office note dated 6/7/2026. Tomorrow will be 60 days, Lordship. Stolen goods has already been recovered. Lordship, 59 days as on today, Lordship.
CD was called for. Otherwise, IO informed that, my lord, due to the date of some his relative, he went there. That tomorrow he will join. Otherwise, I leave it to your lordship because, my lord, co-accused was granted privilege of
Yes, my
anticipatory
brother-
bail, my.
He's already on pre-arrest interim bail.
Earlier, it is rejected on, my lord, that is on, my lord, 17/6/2026. That is on, my lord, page 37, my lord, because, my lord,
What is your name?
P. Roy, Lordship.
Third, Mr. P. Roy, learned counsel for the petitioner. Also heard Mr. K. Busho, learned additional public prosecutor. I have also perused the office note dated office note dated 6/7/2026, which indicates that this matter was earlier taken up by a coordinate bench within bracket Honorable Mr. Justice S. K. Sharma. However, since vacations are going on and since the said bench is not available now, this matter was placed before Honorable the Chief Justice, and after his Lordship's order, this matter has been listed before this bench. This application under section 483 of BNSS 2023 has been filed by the petitioner Muhammad Naimuddin Ahmed, who has been detained behind the bars since 9/5/2026 in connection with Patase Lambari PS case number 49/2026 under section 123/305 within bracket C of the BNS. Where is the FIR?
FR page 25, Lordship. Type copy.
The facts relevant for consideration of the instant bail application, in brief, are that on 29/4/2026, one Ankit Chaurasia has lodged an FIR before the officer in charge of Patashi Lambari Police Station, inter alia, alleging that on that day at about 2 p.m., one vehicle bearing registration number AS25CC6847 departed from a log godown situated at Datalpara after loading Jarda Pan Masala. And what is your name?
Naimuddin Ahmed, Lordship. I'm not named in the FIR, but the stolen goods were recovered from my possession. That is the allegation against me.
And the said vehicle did not reach its destination. Later on, it was found that the vehicle was completely empty and all loaded goods were missing. Learned counsel for the petitioner has submitted that the petitioner has not been named in the FIR. However, it has been alleged that the missing goods were recovered from his custody. He also submits that his brother, what is your brother's name?
Nawabuddin Ahmed.
Nawabuddin, his brother Nawabuddin Ahmed, who was also suspected to be involved in this case, has already been granted anticipatory bail,
Lordship, interim. I'm on interim, Lordship. Page
Yeah.
34, I have annexed the order.
interim anticipatory bail. By a coordinate bench of this court. He further submits that the petitioner has been detained behind the bars for last 58 days, and day after tomorrow he would be completing his statutory period of detention. Hence, he prays for allowing the petitioner to go on bail. Learned counsel for the petitioner further submits that the petitioner would cooperate in investigation if he is released on bail. On the other hand, learned additional public prosecutor, CD has not been called.
CD was, I think, called for, my lord, on 25/6/2026, my lord.
No, there is no such order.
It was called for in the earlier
In the-
rejected bail application. Here
Oh.
it was not called for.
Where is the rejection order?
Page 37, Lordship. Relevant portion your Lordship will find at page 39.
Learned additional public prosecutor submits that though the petitioner has been behind the bars for last 58 days, however, on an earlier occasion, his bail application was rejected by a coordinate bench of this court. Considering the incriminating materials in the case diary. And while rejecting the bail, the coordinate bench observed that after perusing the case diary, sufficient incriminating materials was found in the case diary. Stop. I have considered the submissions made by learned counsel for both sides. Though the order dated 17/6/2026 passed in bail application number 1540/2026 indicates that there are sufficient incriminating materials against the petitioner in the case diary, however, considering the fact that he has been detained behind the bars for last 58 days and the maximum period for which he can be detained during the course of investigation for the offense alleged in this case is only 60 days. Moreover, one of the co-accused has also been granted interim protection by a coordinate bench of this court. This court, if the petitioner cooperates in investigation, his further custodial detention may not be necessary for fair completion of the investigation of this case. As such, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of learned which court?
CGM Kamrup Metro.
Learned Chief Judicial Magistrate Kamrup Metro, with following conditions. Number 1, number 2. With above, this bail application is accordingly disposed of.
Deeply obliged.
Wait, please, your lordship. Lordship, this is a regular bail application. Lordship, kindly come to the FIR that is on page 15, lordship. Initially, case was registered under 137, that is the 2, lordship. That is the kidnapping, lordship. Now, after that, lordship, the present petitioner who is a 20 years old, lordship, and the victim is 16 years, 8 months, lordship.
OXO is also there.
Yes, lordship. Hard
Right.
evidence has been already been recorded that I have annexed.
Bail issue notice.
Yes, lord.
Heard Mr. B. Chaudhary, learned counsel for the petitioner, also heard Mr. K. Bashar, learned additional public prosecutor. Charge sheeted case.
Yes, lordship, charge sheeted, the victim statement already been recorded, lordship.
Stop. Let the notice be issued to respondent number 2 in pursuant to the notification prevailing, notification of the registry. In this regard, the petitioner shall take steps for issuance of notice to respondent number 2 within 3 days from the date of this order written. No, 14th August.
Oh,
14th August. Let the scanned copy of the
Lordship, 14th August, like, long. Lordship.
short day.
Can it be on reopening, Lordship? Because Lordship, her evidence, she has been declared hostile, Lordship.
16 July. 16 July.
Obliged. Highly obliged.
Let the scanned copy of the trial court records be also requisition.
4 and 5, my lord, pertain to the same case, my lord. Some alpha militants, my lord, they came and they were shot by police. Injuries, my lord, definitely diary, my lord. Can it be on 17th or
4 and 5. Heard Mr. B. Mahajan, learned counsel for the petitioner, also heard Mr. K. Basha. Let the case diary be called for. When? Let this matter be listed on 17th.
highly obliged?
Both cases.
Vote.
Yes,
17th of
My lord,
July.
July.
my lord.
Both cases.
Obliged, my lord.
5 also same.
No, 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 4, 5 same, my lord.
4 and 5.
4 and 5 same, my lord.
Same.
Same order.
Number 6. Oh, sorry.
May I please your Lordships? Lordships, affair is at page number 14.
What is the offense?
Offense is that your Lordships on obtaining and secret informations, the police persons has conducted a raid on a spa. And on that spa, the 7 numbers of girls were recovered and no male persons were recovered, and accordingly.
Who are
FIR was-
you? Who are you?
I am also one of the victim, but the police has mentioned in the FIR that I am the manager. I am not the manager of that spa,
Okay,
Lordship.
case diary. Let the case diary be.
Lordship, Lordships, I am behind the bar since 14/6. And here, Lordship, one more issue.
We'll fix a short date. Heard Mr. P. K.
Lordship, in 47 notice, Lordships may kindly go through that.
We'll go through the case. Case diary will reveal every.
Lordships, in 47 notice, when the notice was issued to the detainee, but it was issued in the English language, which but the detainee did not know the English. So it should not, also the police did not explain it in Assamese also.
Let us go through the case diary.
Also,
Heard
I
Mr.
am already
P.
behind the bar since 25 days.
Heard Mr. P. K. Kulita, learned counsel for the petitioner. Also Mr. K. Bashar. Let the case diary be called for. Let this matter be listed. Well,
13.
No.
13, 13, 13. Let it be 13, my lord.
okay, 13 July.
13. Itu udah kedua Itu udah kedua
Date दिला रमेश July Mahadir. July. Yes.
My lord, the Belsoar PS case, my lord, the petitioner has been arrested on 26. It has been 18 day, 18 days.
Poxco. Poxco.
The Poxo matter.
Pending investigation.
Yes, yes, 8 and 12.
What is your name?
Aurobindo Rath. My name,
Yes.
ready here.
Heard Mr. R.D. Bhuya, learned counsel for the petition. Also heard Mr. K. Bashar. Call for the case diary. Let this matter be listed.
13, my lord, notice to go, my lord. 13, my lord.
Let also the notice be issued to respondent number 2. You have not made the victim or
I mean, the party victim.
No, my lord. Victim is not made.
victim has to be made party. You make her party. Let also notice be issued to respondent, notice be issued to the informant / victim girl in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 20th of July. Let 20 July, list accordingly.
Maybe it's also, this is regular bail application. So FIR is at page 16. So in this case, initially section 87 was as per 87 that yes, it was registered, but after the arrest of the accused person, the section 65(1) and 137 and was also added, lordship.
Okay. Third, Mr. N.J. Gogoi, learned counsel for the petitioner. Also, heard Mr. K. Bashir, learned additional C, public prosecutor. Call for the case diary and issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in person to the prevailing notification of the registry in this regard within 3 days from the date of this order. Let this matter be listed on 22nd of July.
That's it.
22nd July.
Obliged.
Item number 9.
Lordship, the petitioner was arrested on 15/11/2025 in connection with North Lakhimpur PS case number 385.
Also, we are issuing
Also,
notice.
Yes, Lord.
Heard Mr.
Charge sheet has been filed, Your Lordship.
Z. Khalid, learned counsel for the petitioner. Call for the scanned copy of the trial court records as well as issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps within 3 days from the date of this order, returnable on 24th of July.
Obliged.
List second.
May I please, Your Lordship? Lordship, this is a case of NDPS under 21B.
Since when you are behind the bars?
Lordship,
Since when you are behind the bars?
from 7/5/2026. Today, 60 days has been completed, my Lordship.
Yes, Mr. Bashir.
Yes, sir. Interrogate quantity.
Heard Mr. What is the name?
Rakesh Dhar.
Ardhar, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners Bappan Das, number 1, and number 2, Gopesh Das, who are detained behind the bars since 6/5/2026 within bracket for last 60 days in connection with Rania GRPS case number 22/2026 under section 21 within bracket B/29 of the NDPS Act 1985. Where is the affair?
Lordship,
The
FIR page number.
gist of accusation in this case is that on 7/5/2026, one Lotharam Boro, SI of police, has lodged an FIR before officer in charge of Romia GRPS, inter alia, alleging that how much heroin was recovered?
32 gram, my Lordship.
Inter alia, alleging that during a routine platform checking duty at Rangya GRPS on 6/5/2026, wait, where is the quantity mentioned?
Lordship, page number 14. Page number 14. Second last paragraph.
Thirty-three. Why are you saying 35 grams?
33 grams, Lordship.
So it is 33,
33 grams.
not 35. 33 grams of heroin was recovered from the present petitioners. Learned counsel for the petitioner submits that since the weight of the contraband seized in this case is of intermediate quantity, hence maximum period of detention during the course of investigation is 60 days only. And today is the 60th day of the investigation. 60th day of their arrest. Learned counsel for the petitioner also submits that embargo of section 37 of the NDPS Act is not attracted in this case. Learned additional public prosecutor also raises no objection as today is the 60th day.
Okay, my lord, 62 days, so
60, today is the 62nd day of
62, my.
62nd day of his
Yes, yes.
arrest. Stop. Considering the fact, I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Considering the fact that the quantity of contraband seized in this case is of intermediate quantity and considering the period of detention of the present petitioner, he is entitled to get statutory, he is entitled to get bail on the ground of completion of statutory period of detention. As such, the petitioner is allowed to go on bail. Both the petitioners are allowed to go on bail of rupees 50,000 each with one surety of like amount, subject to the satisfaction of learned special judge where which court?
Yeah.
Learned special judge Romia with following conditions. NDPS two conditions. Take it from Abhishek. This bail application is accordingly disposed of.
Hello, bless. Thank you. Thanks.
May please, Lordship. My lord, game and betting, my lord, but IPL, my lord, definitely case diary, my lord, any convenient date like that.
Heard Mr. B.K. Mahajan, learned counsel for the petitioner. Also heard Mr. K. Bush, learned additional public prosecutor. Call for the case diary. Release this matter on 17.
17.
Highly obliged.
17 June.
Obliged, my lord. This is the fishery scam, my lord. Already diaries have been sought for in other bail applications, and the date fixed is, my lord, 16/7, my lord.
Yes, same order. Call for the case diary. Fix on 16/7.
16/7, my lord.
16/7.
Highly obliged, my lord.
Wait, please, your lordship. On the same FIR, another bail petition is pending as item number 50, in which CD has been called for lordship today.
CD is there.
Yes, lordship. 50.
CD is there with the court.
CD has been called and CD has received by them. May be taken up together or I may.
Yes, my lord, city receipt, my lord. Can be taken
Then
together.
we'll
50, my
take up at along with 50.
50,
Wait,
lordship.
wait
Yes,
for.
no problem.
We are behind the bar for last 51 days now.
51 days.
Here the my
What is the offense?
This is died of by committing suicide, but we have alleged that we have killed the deceased my lord. The fact is that my lord, the petitioner number 2 was the wife
We'll
of
call
the.
for the case then. Heard
From Nalbari, already
heard
killed.
Mr. UK Burman, learned counsel for the petitioner, also heard Mr. K. Bushra, learned additional public prosecutor. Call for the case diary. Release this matter when, Mr.
For the matter.
Already said 51 days. 50 days.
Short date. 16th of July. 16th July.
Obliged.
Maybe. Fifth petitioner is behind the bar 44 days.
44.
Allegation, my lord, murder, my lord, 103, my lord.
Heard Mr. M. Hope. Call for the case. K. Bushra, call for the case diary. Release this matter on 22nd July.
Obliged.
Me at least, lordship, my lord, 483 regular bail, my lord. Petitioner arrested on 8/6/2026, my lord.
What is the offense?
Yes, my lord.
What is the offense?
Offense under section 296 and 118 to BNS Act, my lord. My lord, kindly peruse page 17, my lord. On earlier, on a bail application was referred in the CGM, my lord. That petition was rejected, my lord. And in the, if you kindly peruse the order on 36/2026, my lord. Already, police has sent a report, my lord.
We'll call for the case diary. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor. Call for the case diary. Let this matter be listed on 22nd July.
Obliged, lord.
My lord, may I pray for withdrawal of this, my lord, the petition or some technical problem is there.
Heard Mr. M. H. Ahmed, learned counsel for the petitioner, who prays for allowing the petitioners to withdraw this instant bail application. The prayer is allowed. This bail application is dismissed from withdrawal.
So, liberty may be
Liberty is not required.
not necessary, lordship. All right.
Wait, please, your lordship. Lordship, this is a regular bail, lordship. Here, clear violation of section 58 of the BNSS, lordship. Here, within 24 hours, this petitioner was not produced before the CGM, lordship. May I take you the lordship? This FR lordship, 149 bottles of cough syrup recovered from a vehicle, lordship. It said it's from the petitioner, lordship.
Yes, sir. Yes, sir. 22C.
Yes.
20, but lordship, can you see, lordship, the seizure list, lordship? That is on page 28, lordship. Date and time of seizure.
Yes.
7/5/2026 at 8:41 PM.
Yes.
That is the seizure. And he was produced before the CGM, lordship. That is, lordship will find on page 42, lordship.
Yes.
On 9/5/2026. More than 24 hours, lordship.
We don't know when you were arrested.
Arrested, lordship, arrest memo, lordship will find on page 34, lordship. Because seizure has made on 7/5, lordship, but arrest has been shown on 8/5. Whole night he was in police station, lordship. That within 24 hours he was not present, lordship. They shown his arrest on 8/5, lordship. Then produce.
We will call for the case diary.
Yes, lord, short date, lordship. Because
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor. Learned counsel for the petitioner submits that in the instant case, though the commercial quantity of contraband is involved, however, the fundamental rights of the petitioner was violated by not producing him within 24, producing him before the nearest magistrate within 24 hours from the time of his arrest. Stop. To appreciate the contentions raised by the petitioner, perusal of the case diary would be necessary. Hence, call for the case diary. List this matter. 15th of July.
Obliged.
My lordship, 32 days behind the bar, my lord. Section involves 21B.
We'll call for the case diary.
Sorry.
Heard, Mr. What is your name?
J. Ahmed, my lord.
J. Ahmed. Learned counsel for the petitioner, also heard Mr. K. Bashir, learned additional public prosecutor. Call for the case diary. Let this matter be listed on 16th of July.
Obliged.
May it please your lordship.
Yes.
Application for PRS bail, your lordship, FI at page 12. The translated copy I have annexed. If I may read
Yeah.
your lordship. It is respectfully stated that today evening at around 8 p.m. at my house, Himanshu Das and Saurabh Das is the petitioner here, forcefully entered my house and using sharp weapon attacked my husband and tried to kill me. My husband, in fear of his life, leaves, and in that chance, when I was alone with my child, Saurabh Das and Himanshu Das threatened to rape me and threatened to kill my only child with his Thar vehicle 6666. Both of them together made video of me and defamed me by alleging that I ran prostitution. As they have threatened to kill my husband and threatened to rape me and my family feel unsafe. Your lordship, what happened actually? The co-accused Himanshu Das is the neighbor. They both refer the complainant, informant, and Himanshu Das. They reside in the same building, your lordship. I was invited as a guest, so there was some minor argument regarding parking of my motorcycle. This Thar vehicle is not mine. I don't know whose vehicle is this. My motorcycle was parked, and what happened? The husband of the informant, he parked another motorcycle in front of my bike, and so I could not take it out, and that's how our argument took place. Your lordship, the Himanshu Das was arrested, and he was also granted bail by the Thane Session Court. I have the copy of the bail. The case diary reflects whatever I am submitting, your lordship. The first 4 paragraphs are, your lordship, regarding the submission made by the counsels. Paragraph 5 at page 2, your lordship. Case diary reflects that IO has recorded the statements of the witnesses, and from the case diary, it appears that on that day of occurrence, one incident related to parking of a motorcycle by the tenant of the informant had taken place, and in that incident, another person assaulted the husband of the informant with fist. So this is the case, your lordship.
Case diary will call.
At this stage, I may be protected, your
Heard,
lordship.
Mr. What is your name? P.K. Sharma.
Okay.
P.K. Sharma, learned counsel for the petitioner. This application under section 482 of BNSS 2023 has been preferred by the petitioner Saurav Das, who is apprehending his arrest in connection with Lata Sil PS case number 38/2026 under section 109/333/351 within bracket 3/356 within bracket 2/75 within bracket 3/3 within bracket 5 of BNS 2023. The gist of accusation in this case is that on 18/6/2026, the victim woman lodged an affair before the officer in charge of Lata Sin police station, inter alia, alleging that the present petitioner, along with one Himanshu Das, trespassed into her house and attacked her husband And when the attacked her husband stopped, when the husband of the informant escaped from the place, they threatened to rape the first informant and kill her child, and also level certain allegations against the informant. The learned counsel for the petitioner submits that the allegations leveled in the FIR against the present petitioner are not true. He submits that there was an altercation regarding parking of a vehicle in front of the house of the victim / first informant, which has been exaggerated in the FIR. He further submits that in the meanwhile, co-accused Himanshu Das was already been arrested and he has been granted bail by the Court of Learned Session Judge Kamrup Metro in bail application number 471/2026 on 3/7/2026. Learned counsel for the petitioner further submits that while granting the bail to the co-accused, the Learned Session Judge, after perusing the case diary, has observed that the incident is related to parking of a motorcycle by the tenant of the informant and which led to assault of the husband of the informant. Now, learned counsel for the petitioner further submits that the petitioner is ready to cooperate in the investigation. So, on the other hand, learned additional public prosecutor prays for calling the case diary. Stop. Let the case diary be called for. Let this matter be listed again on 27th of July. In the meanwhile, considering the fact that the co-accused of this case has already been granted bail and also considering the observations made by the learned session judge while granting bail to the co-accused, the present petitioner, namely Saurav Das, is directed to appear before the investigating officer of Latasil PS case number 38/2026 within 7 days from the date of this order and cooperate in the investigation. Stop. If he does so, within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of rupees 30,000 with one security of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and number 2. Let this matter be listed again on 27th July for case diary.
Highly obliged, Lordship. Highly obliged.
May it please your lordship. 482 application. But I am one of the owner of the Goshala situated in South Salmara district. And all the accused are owner of the Goshalas. And my lord, on inquiry it is found that cows or buffaloes are missing from their Goshalas. And accordingly, authority has filed a case, my lord, FIR. And case is now charge sheet of 406 and 379.
Charge sheeted.
Charge sheet has been given against us. And most of them have obtained bail from Honorable High Court, my lord. I also got a summon when I appeared. I have submitted an application and fixing.
No, if it is charge sheeted case, the trial court will grant you bail.
Well, that's true. But
Then why have you rushed?
yeah, my bail petition may not be granted because
Why?
all of them have obtained bail from High Court, my lord.
No, that cannot be a reason for rushing to High Court.
But if your lordship dispose it with the direction to consider my bail prayer on my appearance, I have got no objection.
You have received summons from the court.
Beg your pardon?
You have received summons from the trial court.
Yes, I have appeared and I have taken time to appear.
When?
Next date is fixed on 26/7.
Pray before trial court on
Yes.
26/7. Heard Mr. S.C. Bishwas, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Ajay Paul, who is apprehending his arrest in connection with Sukhchar PS case number 84/2023 under section 120B/406/379 of the Indian Penal Code, corresponding to PR case number 369/2025, pending before the Court of London. Additional Chief Judicial Magistrate South Salma Mankasa. The gist of accusation in this case is that on 4/3/2023, one Prasad Chandra Rai had lodged an FIR before the officer in charge of Sukhchar police station, inter alia, alleging that during an inquiry done by the informant, it was found that many cattle are missing from Goshala / pound, POUND, pound. And therefore, it was suspected that the cattle were stolen or disposed of otherwise. Learned counsel for the petitioner has submitted that in this case, charge sheet has already been laid and the petitioner has received summons from the trial court. And
On 3/6/26, I submitted an
And
application.
3/6/2026, the petitioner filed an application before the trial court seeking adjournment. He submits that the next date of the case is fixed on 26/7/2026. Stop.
Not 26, 31/7, madam.
31/7/2026. On a bail, now on consideration of the submissions made by learned counsel for the petitioner, this court sees no apprehension of the petitioner getting arrested, as the trial court has only issued summons to it, and the trial court is competent enough to consider the prayer for bail if such an application is moved before the trial court. Hence, this anticipatory bail application is disposed of with an observation that if so advised, the petitioner may move an application for bail before the trial court on the next date fixed, that is on 30/7/2026, on his appearance before the trial court, and same shall be considered as per law by the trial court.
As per law, my lord, he may not consider. If
So,
not to give objection, all cases have been considered by the High Court and the.
He is already, my lord, in previous bail, my lord. Already in the search sheet, it is reflected earlier, he is in previous bail, my lord. On that day, my lord, his, my lord, contention is that, my lord, he is absence of documents of his bailer as cause of his absence, and that is allowed, my lord.
I leave it to your lord. My lord, this is also 482 application, my lord. After a charge sheet, my lord, summons has been issued, but I could not appear, my lord. That's why, my lord, I applied for the non-bailable bail, pre-arrest bail. My case was rejected, my lord, but other co-accused has been granted, my lord. Page 41, your lordship will find.
No, whether the trial court issued any non-bailable warrant of arrest.
My lord, I have a non-bail warrant of arrest is also issued against me.
Where,
I'll show you, my lord. My lord, page 39 kindly. Non-bail issued against the co-accused Bapandhar has not returned yet issued fresh. I am willing to appear, my lord, kindly.
who are you?
I am a co-accused, my lord. Charge sheet has been filed.
No, what is your name?
Bapandhar,
Where is the no?
page 39.
Okay.
Order dated 8/6/26.
When is the next date? When is the next date?
My lord, other two accused, my lord, Pradut and then Prabhat, they have been considered, my lord.
No, my question is when is the next date of?
Oh, next date is, my lord, 12/8, my lord. I
Right.
will appear before that, my lord.
No, you appear on 12/8 till 12/8.
Right.
We'll
Because no-
give you protection.
Yes, kindly.
Heard Mr. S.C. Bishwas, learned counsel for the petitioner. Also heard Mr. K. Basha, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Bapandhar alias Bapandhar in connection with PR case number 2633/2023 under section 307/325. Under what provision charge sheet has been laid?
307/326. Because
325.
I have annexed medical report, my lord. Only injuries on the leg and hand, my lord. So
Slash
idle part
three-
is not there.
326/34 of the Indian Penal Code, which is pending before the Court of London. Judicial Magistrate First Class Number 2 Kachar Silchar. Learned counsel for the petitioner has submitted that in the aforesaid case, charge sheet has been laid against the present petitioner under the aforementioned penal provisions. He submits that initially summons were issued against the petitioner by the trial court. However, as the petition, why you did not appear after summons?
I have engaged a lawyer, my lord, with a prayer, requested him to take an adjournment. He did not appear. I couldn't appear because there was a personal problem in my home, my lord.
However, in spite of issuance of receipt of summons, he could not appear before the trial court due to some personal difficulties. He submits that in the meanwhile, trial court has issued non-bailable warrant of arrest against him and fixed the next date of appearance on 12/8/2026. Stop. Learned counsel for the petitioner submits that the petitioner is ready to face trial. However, since non-bailable warrant has been issued against him, he is apprehending that he may be arrested at any time in connection with the aforesaid case. I have considered the submissions made by learned counsel for both sides. Stop. Since a petitioner is ready to face the trial,
Other coaches
and
have been
since
granted bail.
the
also.
other two co-accused, namely Pradyut De and Prabhat De, are on bail, the present petitioner is directed to appear before the trial court on the next date fixed 12/8, that is 12/8/2026, to facilitate his appearance before the trial court on the next date fixed. The non-available warrant of arrest issued against the present petitioner shall not be executed against him. On his appearance before the trial court, the petitioner may pray for a regular bail before the said court. With above observation, this anticipatory bail application is disposed of.
Diplomat.
May it please your lordship. Lordship, this pre-arrest bail seeker on the ground, lordship, kindly come to the page, lordship, paragraph 2 and 3, lordship. What happened, lordship? One Shahar Ali, lordship, has entered into an agreement with this petitioner for sale of a land, lordship. And accordingly, lordship, for a consideration of 19 lakhs, lordship. Out of that, lordship, he has paid 7 lakhs, lordship. Remaining amount he has to pay within 6 months, lordship. Then he has failed to pay that remaining amount, lordship. Now he is refused to take that land, lordship. Now, lordship, this petitioner said, lordship, after selling of that land, lordship, he can refund his money, lordship. But without that, giving him that time, lordship, he has approached the Mukalma police, and Mukalma police, lordship, visited the house of this petitioner, lordship.
Where is the case?
Case number, that is, lordship, they have visited my house in search of this petitioner, lordship. Let the report may be called for, lordship. In the meantime, lordship, no coercive action against this petitioner.
In
Because-
which case? In which case you get?
That is, lordship, this, in that, lordship, we could not obtain the case number, lordship.
So
They have
what direction this court? will-
only, lordship, a report may be called for, lordship, whether any case is pending.
Report we will call for. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also Mr. K. Bushra, learned additional public prosecutor. This application under section 482 of BNS 2023 has been filed by the petitioner Azizur Rahman, who is apprehending that Mukalma police may arrest him in connection with an FIR which might have been lodged by whom?
Shahar Ali, lordship. I've stated in my lordship.
Shahar. However, he is not aware of any pending case against him, but he submits that. But the Mukalma police has visited his house in search of him. Stop. Since the petitioner has been unable to give any details of any pending case against him or any FIR lodged against him at Mukalma police station, let a report be called for from the officer in charge of Mukalma police station as to whether any FIR has been lodged by one Shahar Ali against the present petitioner, and whether any such FIR has been registered or not. The report should reach this court by 22nd July.
Can it be on 9, because lordship, he has no protection, lordship, police. 9 or
No.
on
13.
13.
On 13th July, through the office of learning public prosecutor.
But
Yeah.
lordship, repeatedly they visited our house, lordship, that I have stated in my paragraphs, lordship. Kindly no coercive action till lordship.
You inquire.
That lordship, that is the problem, lordship. They are not providing any number. They ask this petitioner come to the police station, lordship. Without having lordship proper content of the case, lordship. Only things, lordship, this petitioner apprehension of the only on that ground, lordship, regarding that sale deed, lordship.
Blanket protection. Let us wait for 13.
Obliged.
Application for pre-arrest bail, your lordship, FIR at page 16.
UAPA.
Your Lordship, I am not at all involved, Your Lordship, that the basic allegations in the FIR are that certain persons, businessmen of Dhemaji, were subjected to extortion demands by two suspected alpha cadres. One is Major Abhimanyu Ohom and another
Where is the FIR?
as page 16.
Yes. Who are you?
I'm not a name accused.
What is your name?
My name is Subimol Padun. I'm a businessman. Your Lordship, the allegations in the FIR, if I may read, Your Lordship.
Yes. Then why are you apprehending your arrest?
Yes, what happened actually, Your Lordship, just one paragraph, if I may read, Your Lordship, of the FIR, then everything will be clear. The third paragraph.
Yes.
At the conclusion of the preliminary inquiry, it has been established that the businessmen so-and-so were subject to extortion demands allegedly issued in the Alpha pad by two persons suspected to be cadres of Alpha, namely so-and-so and so-and-so. It is also suspected that some local active collaborators, on-ground worker, may be involved in facilitating such extortion activities. Now, this last sentence, on the basis of this, Your Lordship, two persons were arrested. One is Ankujuti Gogoi and another is Bidyut Buragohai. These two persons are aged about 28, 29, 30 years old. So these, I'm 41-year-old and I'm a reputed businessman of that locality. I have annexed all the documents. I'm a class 1A contractor. So what happened, Your Lordship, even though there is nothing on record, the police officials, they call me. I was in Kedarnath when the police officials called me, saying that one of the arrested person, Bidyut Buragohai, has mentioned my name as a known person. That is the only thing. Now,
Known means?
Lordship?
Known person means?
Known person, actually what happened, Your Lordship, this Bidyut Buragohai is much younger than me. And I am not at all aware whether he is into this extortion or he is a ground worker of Alpha or not. But he sometimes approaches me for small works, and I, being a reputed contractor of that locality, it's a small village, Your Lordship. So I help the young person. That is the only thing that that's how I know.
UAPA is there, my lord. My lord, CDB come.
Yes, CD may come, Your Lordship. Only thing is, if I can just give my statement, then everything will be clear. I just want to go and give a statement. But the police officials, they have themselves said that since this
Any embargo is there?
embargo is not there,
Because section 10 and 13 of UAPA.
10 and 13.
10 and 13 of UAPA.
No embargo.
Otherwise, my lord, it is on 26/3/2026.
And the FIR is of 27/3, 3 months old.
Now,
I am not at all involved. Your
no,
Lordship, kindly
why
tell-
are you apprehending arrest?
Because the police official says that one of the person who is alleged
No,
to be a
whether
ground
police
worker,
told you that they will be arresting you. Or
since the sections are non-bailable, they will be left with no other option but to arrest me. That is the only apprehension.
no, where is
In the
this
man-
this statement in the bail application
Yes.
where you have shown your apprehension? Ramesh,
Paragraph 7 is the paragraph where I have mentioned
UAPA,
the reason.
unlawful activities. Prevention. Unlawful activities prevention.
Paragraph 7, the entire paragraph, if I may read, Your Lordship, at page 5. That the accused petition most suspectly says that almost after a lapse of 3 months from the date of registration of the FIR, the police authorities have proceeded to arrest one Bidyut Buragohai on 24/6/2026 in connection with the instant case. The petitioner stated that he is only casually acquainted with said Bidyut Buragohai, who is a young boy from the same locality, and that such acquaintance is limited in nature. The said individual having at best
The
attempted
police
to
is
maintain...
summoning you to police station.
Yes, it's coming after in the same paragraph to maintain cordiality with the so-and-so. It is further subjected
Heard, Mr.
solely on account of
What
such
is your
seriousness.
name?
The police officials,
What is your name?
PK Sharma.
Heard, Mr. P.K. Sharma, learned counsel for the petitioner. Also heard Mr. K. Basho, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Subimal Padun, who is apprehending his arrest in connection with Dhemaji PS case number 59/2026, under section 62 within bracket 2 slash 308 within bracket 4 of BNS read with section 10/13 of UAP UA within bracket Unlawful Activities Prevention Act 1967. The gist of accusation in this case is that on 26/3/2026, one Dhojo Borpatro, SI of police, had lodged an FIR before the officer in charge of Dhemaji police station, inter alia alleging that some persons have received extortion extortion letters from members of banned organization, namely United Liberation Front of Assam within bracket I. The FIR names few persons involved in the alleged offense and also indicates that some local active collaborators may also be involved in facilitating extortion activities. Learned counsel for the petitioner submits that the petitioner is in no way involved in the offense alleged in the FIR. However, he has received telephone call from Dhemaji police station inter alia stating to him that in connection with the aforesaid case, one Bidyut Buraguhai, who is a known person to the present petitioner, has also been arrested. And in that connection, the police is repeatedly asking him to appear before the police station. Learned counsel for the petitioner submits that the petitioner is ready to approach the police and cooperate in the investigation. However, since non-bailable offences are involved in this case, he apprehends that he may also be arrested in connection with the aforesaid case if he appears before the police without any protection. On the other hand,
Because my lord, section 10 and 13 is there, my lord. It comes under my lord, chapter 3, my lord. So, my lord,
45D bar is there.
Yes, my lord. If my lord, I am not wrong, my lord, that bar is there in case of section 10 and 13, my lord.
Kot kitab kon ko. Unlawful activities prevention. You have checked it. अपनी साव unlawful activities prevention. Yes. Check it.
There is no bar as far as I'm concerned. There is no bar. Chapter 3 তেনেকুৱা ফটোলৈকে bar নাই কৰিবি।
এনেকে বিচাৰিলে আজি বিচাৰি নাপাব। চেম্বাৰত চাওক।
Allow me then sometime, my lord, within that time I will go through that matter, particular that part, my lord. On that.
Okay, you also very itu আধাতে ৰখাই দিয়ক।
That part.
Worship.
Let him verify.
Right.
Let me
That
get
part.
the book.
Only that part.
Let me get the book.
Yes,
We'll
Lord.
take it up after some.
Lord. May I please, your lord?
Lordships, here the FR is at, this is page 11. Here I am not directly involved accused in the affair, Lordship. The affair,
Just a minute. We'll take it up after some time.
Lordship.
We got the book. Now, the next item.
Head to look on. Have done this. Head to look on.
Okay. 45D bar 5 operates only for offense punishable in chapter 4 and 6.
4 and 6, and section 13 is chapter 3, Your Lordship. So this bar under 43D subsection 5 is only for chapter 4 and 5.
Yes. Yes, Mr. Busha. Ramesh. কি লিখেছিলে আগত লাস্ট On the other hand, Mr. K. Basha, learned public prosecutor, submits that the offense involved in this case is of serious nature under the provisions of Unlawful Activities Prevention Act 1967. Hence, case diary may be called for. Stop. Let the case diary be called for. Let this matter be listed on 24th of July. 24th of July. In the meanwhile, since the offense under Unlawful Activities Prevention Act 1967, which are involved in this case, are not covered under the embargo of section 43D within bracket 5 of the Unlawful Activities Prevention Act 1967, and since the petitioners are not named in the FIR, they are directed to appear before he is directed to appear before the investigating officer of Dhemaji Police Station, case number 59/2026, within 7 days from the date of this order and cooperate in investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Number 1, conditions, Abhishek or Parloilu. Number 1 and number 2. Let this matter be listed again on 24th July.
Highly obliged. Highly obliged.
My lord. Here the FIR is at page 14, my lord. And in the FIR, lordships, my name has mentioned in one thing that trade license of the spy is in my name. That is the only apprehension of my arrest. And on that contents of that apprehension, the police has searching me because the trade license of the spy is only in my name, and I am no more related with the activities of the spy. And Lordship.
Spa is in your name.
No, spa trade license is in my name, but it is maintained by one, that is Onil Boro. He has already been arrested.
Onil Boro is
Onil
the
Boro.
owner.
Onil Boro is a caretaker and he has already been arrested. And he has maintaining everything on the spa. And I am out of spa because I remain busy in other business. I never visited the spa also. And on the day of incident also, I was
Then
not
why
present.
have you obtained trade license?
No, it was obtained trade license for the spa only, but no illegal, for any illegal activities, it was not obtained also. But it was maintained by Onil Boro. What
Yes,
Onil
Mr.
Boro?
Bosho.
FIR is not, my lord, before us.
FIR named. You are Sonmuni Das.
Yes, Lordship.
Case diary would be required.
In the meantime, I may be protected so that I can give a statement before the IO. So I was not present, nor there was no any involvement of myself on that spa. Lordship.
No, but allegations are against you only in the
No,
first.
allegations are against me only on the basis of that, Lordship. The state license is in my name, but my intention was not to do any illegal activities in the spa, and that's why the Onil Boro was taking care, and he has been maintaining everything, and that Onil Boro has already
In a
been arrested.
connected case, case diary was called for.
Lordship,
In a connected case, which you moved.
Lordship, earlier in item number 5.
When the same case,
FIR is same.
when the case diary has been called for,
It was on 13th.
case diary would be required.
In the meantime, Lordship, I may be protected to
No.
appear before the IO. I will cooperate with the investigation,
After
Lordship.
13, heard Mr. P.K. Kalita, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. Considering the nature of allegations involved in this case, perusal of the case diary would be necessary for consideration of the instant bail application, anticipatory bail application. Hence, call for the same. Let this matter be listed again on 13th of
So, interim
July.
protections, if you look.
No.
I live.
My please, Your Lordship, this anticipatory bail is in connection with a probable FIR that may have been lodged against me. The brief factor is that on 36, I received a phone call from Polasbury PS stating that one Purubi Majumdar has appeared before that PS for lodging an FIR, and I was called for. But no case number or anything was given to me, so I inquired with the PI court, but nothing came out
We'll call for
for
the
the report, Your Lordship.
report. What is
If Your Lordship may consider interim
what interim?
at this place, if I may be arrested in connection with any Polasbury case.
Which case? Any case? So that you can
No
do
blanket.
anything.
I don't want any blanket cover, but if
Then-
the FIR informant is the same, if possible, Your Lordship.
We are fixing a very short date.
Yes, Your Lordship.
Heard Mr. M.R. Sodian, learned counsel for the petitioner. This application under section 482 of BNSS has been filed by one Sonmani Nath, who is apprehending his arrest in connection with a case which might have been registered against him on the basis of an application filed on the basis of an FIR filed by who is the
Purabi Majumdar, paragraph number 3.
Purubi Majumdar before Palashbari police station. Stop. Learned counsel for the petitioner submits that the petitioner is not aware of the fact as to whether any FIR has been registered against him in Palashbari police station or not. Hence, he prays for calling for a report and grant of some interim protection to the petitioner. Let a report be called for from the officer in charge of Palashbari police station as to whether any FIR has been registered against the petitioner Sonmini Nath in Palashbari police station on the basis of filing of such filing of any such FIR by one Purobi
Majumdar.
Majumdar. Let the report be sent to this court through the Office of Public Prosecutor on or before the next date fixed. Let this matter be 15th of July.
Deeply obliged.
May I please, my lord? My lord, in this, my lord, FIR on page 20, my lord. In this case, my lord, the allegation is that, my lord, the brother-in-law of the informant, my lord, possessing a land, my lord, due to the land dispute, my lord, when they put some bamboo barricade, my lord, then, my lord, the present present petitioner, including the other accused, my lord, come and the severally, my lord, beaten them, my lord, due to the severe injury, my lord. But, my lord, actual fact is that, my lord, the petitioner number 2, my lord, who submitted a title suit, my lord, before the, my lord, concerned court, my lord, in the senior division, my lord, where, my lord, the husband of the informant, my lord, is a defendant, my lord. On the same incident, my lord, another FIR also lodged, my lord. The wife of the accused number 4, my lord, she also lodged an FIR, my lord. Said FIR is on page 31, my lord. Both the FIR was initially primarily inquired by the investigating officer, my lord, and found this both the investigators true, my lord. My lord, considering, my lord, two rivalry fact, my lord, where, my lord, in this first FIR, my lord, we are the accused, my lord, including present petitioner, my lord, and the second FIR, my lord, the husband of the informant along with the other person of the accused, my lord. So considering both the rivalry fact, my lord, at least, my lord, at this stage, my lord, lordship may give some interim protection, my lord.
What is the status of the FIR filed by the wife of the accused number 4?
Well, page 31, my lord.
What is the status of the accused in that case?
Well, that case also, my lord, they are severely beaten, my lord, and hospitalized, my lord, presently under treatment, my lord, in the Barpata Medical College, my lord.
Whether are they on bail or?
No, my lord, I have no information, my lord, in this regard, my lord.
Yes, Mr. Bush. We'll call for the case diary fixing a short date.
Till then, my lord, some protection may given, my lord. My lord, this
No, we don't know nature of injury. Who has been?
petition number 1 is a government employee, my lord. My lord, at least, my lord, some protection to give him to, my lord. Petition number 1, my lord.
But petitioner number 1 may be the main accused person.
No, my lord, there is no specific allegation against the petition number 1, though they are in generally, my lord, all are accusers involved is as stated in the FIR, my lord, but there is no specific allegation against any accused person, my lord. Even, my lord, the petitioner number 2, who is the plaintiff, my lord, in the title suit, my lord. That's it. Title suit number is, my lord, 81/2024, my lord. Pending before the civil judge, senior division, Barpeta, my lord.
No, till 13th, we will fix.
Lordship,
Till
it's upon your lordship, my lord.
heard Mr. K.M. Hussain, learned counsel for the petitioner. Petitioners also heard Mr. K. Bashaw, learned additional public prosecutor. Considering the contentions raised in this anticipatory bail application and nature of offense involved in this case, as well as considering the fact that there is a cross FIR filed against the husband of the informant, husband and other relatives of the informants of the FIR against the present petitioners, perusal of the case diary would be necessary. Hence, call for the case diary of Barpeta PS case number 196/2026. List this matter on 13th.
Also, my lord, page 197 will also.
197 may not be necessary.
My lord, it's upon your lordship.
13th.
My lord.
13th July.
Obliged, my lord.
Lordship, it's an AP under 482 BNSS. The FIR translated copy is in page 11 to 12, Lordship. May I read?
What is the offense?
Offenses under section 296, 117, 2 and 76, and 3(5) is the common intention, Lordship. 3 accused person. Actually, the offenses that they, all these, the informant and the accused are,
Where is the affair?
FIR is in page 11 to 12. Translated copy. May I read, Lordship?
The victim was hospitalized for 1 day.
He was hospitalized for 1 day, and after that day,
Yes, Mr. Lokor.
That is also that he was 1 day he was staying at, he was at hospital also. So also medical report, we do not know what is there also. But from the second paragraph, it says also that rose and all there are so many weapon used or I guess.
no weapons has been used, Lordship. CD may be called for, and in the meantime, we may be protected.
Heard Mr. Heard Miss, what is your name?
J. Das, Lordship.
J. Das, learned counsel for the petitioner. Also heard Mr. P.S. Lokor, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners, namely Paritosh Vaishnav, Ashu Vaishnav alias Piyush Vaishnav, Ratan Vaishnav alias Bapan Vaishnav, who are apprehending their arrests in connection with Silchar PS case number 333/2026 under section 296/117 within bracket 2/76/3 within bracket 5 of BNS 2023. The gist of accusation in this case is that on 11/4
On
on
26,
20
26,
when the affair was lodged on 28/3/2026, one Sujit Vaishnav had lodged an affair before the officer in charge of Tarapur town outpost under Silchar police station, inter alia, alleging that the present petitioners who are named as accused in the FIR have on 26/9/2026 at about 6:30 a.m. assaulted the informant and his wife, causing injuries on their person. What is your submission?
my submission is that, Lordship, they are tenants actually, all the informant as well as they are tenants in a common premises, and they had altercation like every now and then. Both the parties has altercation, but they did not, this incident did not happen. Like the accused person did not allegedly, like as they are alleging that they punched the informant as well as his wife. This did not happen. Only verbal verbal.
He was hospitalized.
He was hospital. He just went in the this verbal thing. There was like snatching and that things happened. Not punch and
Why he
severe
went?
injury.
Why he went to hospital?
That the medical report will say, your lordship. The thing is that, as per my knowledge, he was not he was not in such a serious condition that he would have been hospitalized for 1 day.
We'll peruse the case diary.
In the meantime,
Last line.
we may be protected.
Last line. On their person. Subordinate counsel for the petitioner submits that the petitioners as well as the informant are tenants staying in common premises, and there used to be occasional altercations amongst them. She further submits that on the alleged, on the said date, that is on 26/3/2026 also, there was some altercation between them. However, the accusation of assault and causing injury made in the FIR has been exaggerated by the informant. She submits that the petitioners are ready to cooperate in the investigation. On the other hand, an additional public prosecutor pays for calling of the case diary. Let the case diary be called for. Let this matter be listed on 27th of July.
We may be protected in the meantime, lordship.
In the meanwhile, the petitioners are directed to appear before the officer in charge of directed to appear before the investigating officer of Silchar PS case number 333/2026 and cooperate in the investigation. So, if they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to following conditions. Conditions take from Abhishek Upal. Following condition. Let this matter be listed accordingly. 27 July.
Right.
In this case, the petitioner number 1 has given forward with dear lordship. Initially, I did not my lord file Bakalatnama lordship. Now, here in this case, the petitioner number 1 is a my lord engineer my lord completed from NIT my lord Shilchar. My lord, after having my lord completing my lord his course lordship, he was my lord also working in a company lordship, private company my lord, then resigned, and my lord he himself my lord registered a my lord company lordship. My lord, the business of the company my lord to hire vehicles lordship, and thereafter my lord those vehicles are my lord rehired to the individuals lordship. My lord, the one my lord Sarfaraz Ahmed lordship hired a vehicle lordship on 18 my lord 6/2026 my lord for a period of 1 week up to my lord 22/6/2026 lordship. My lord, after on 22/6/2026 lordship, the police OC from Bopata police station my lord informed the petitioner my lord that the vehicle was involved in stealing my lord goat lordship. Then my lord he had given the my lord GPS location everything to the my lord police station lordship or C lordship. Then my lord his operational manager the petition number 2 was sent to the police station on 23/6/2026 lordship. My lord, he was confined, my lord, he was not released, lordship, on next day, lordship. My lord, on 24, my lord, he was released, my lord, all the night he was physically tortured, lordship. Thereafter, my lord, he wrote a letter to the SP, my lord, mail lordship, from mail lordship, and an application before the HR, my lord, Human Rights Commission was given, lordship. My lord, on such application, lordship, a notice was served upon the my lord, the petitioner number 1, my lord, that is at page, kindly see at page 26, at page 14, 14 lordship. This is the notice, lordship. Actually, this notice was served on 26th, lordship. 26/6/2026, lordship. And that was, date of appearance was also given on 26/2026, lordship.
In connection with what affair?
GD&T, lordship. No case was
Where is the GD&T?
My lord, that is, my lord, in the notice itself. Not so in the notice itself, lordship, it is written, lordship. GD&T number 45 of 2026, lordship. At page,
No, on the basis of this GD&T,
at page 14, lordship.
whether any police station case was registered,
No, lordship. No
then,
case was
then
registered.
why
lordship.
are you apprehending?
The petition number 2 was confined, lordship. Now, in view of this, my lord, this below this notice, lordship, is in violation, my lord, he will be arrested, my lord, under section 335 of the BINSS, lordship. Now, in such a case, the dishonorable court has protected, lordship, some other petitioner.
When you were directed to appear? 26.
It was on 26/6/2026.
You did not appear.
My lord, because, my lord, it was received on 26/6, lordship. I have stated in my lord, paragraph 3 of this petition, lordship. Paragraph 8, my lord, paragraph 6, I have stated, lordship. So there is apprehension, lordship, if I appear, lordship, I am not an individual. On the other hand, the vehicle
In
was.
which case you will be arrested?
My lord, the GD&T, lordship. In the GD&T notice was issued, lordship. No case was registered, lordship. Why the petitioner number 2, the operational manager was confined whole the night without registering a case, and physical torture was there. I've written it to the my lord, SP also, my lord. Because of, my lord, writing to the SP and the Human Rights Commission, lordship, my lord, the police,
Now, where is petitioner number 2 now?
Sorry, lordship.
Where is he, petitioner?
Now he has been released, my lord. Next day he was released, lordship. He appeared on 23/6/2024. As per instruction, he went to the police station voluntarily.
Where is that statement?
Yes, lordship, I've stated, lordship.
So
My lord,
he went to the police station and subsequently he was allowed to come out from the
Yes.
police station. Then where is the
Lordship.
he will be arrested, lordship, again also.
At paragraph,
And this is a part of investigation.
at paragraph 12, my lord, 10 and 12, kindly see, lordship.
We'll call for a report as to whether any police station case has been registered on the basis of said.
Yes, till then, no coercion, coercive action may be taken, lordship. My lord,
Also, at least
as was, my lord, protected in other case, lordship, this honorable court, my lord. Lisa, what
In all cases,
I'll kindly
all
see that
nature
order,
of
lordship.
process, that is different,
What is
because
this?
sir, here in this
This
case.
case is, this protection is in this case or a similar case?
That particular case, some other person, lordship. This is
Some
my lord,
other
Rohit.
person, some other
Wrong.
case,
Yes,
some
lord.
other facts, some other judge.
Yes, lordship, coordinate bench, lordship, this honorable court, lordship. That is why I am submitting. And the GD&T, lordship, as per Gurbakh Singh's case, lordship, my lord, anticipatory bail, lordship, the affair is not, my lord, condition precedent, lordship. If my my lord, apprehension is there, lordship, then, my lord, this honorable court can grant arrest bail. Now, my lord, report may be called for, lordship. Till then, my lord, some sort of protection may be given, lordship. Otherwise, my lord, I am a, my lord, proprietor of company, lordship, and the petition number 2 is, my lord, the operational manager, lordship. On the other hand, vehicle was recovered, lordship, from the possession of that hirer, lordship, is Sarfaraz Ahmed.
Heard Mr. M.H. Ahmed.
As he was lordship allowed to come out on when he was on 20, but he was brought to the police station. He was not arrested, lordship. He was allowed to come out. So lordship, whether today why there is a apprehension, lordship? Simply
Because he was kept for one night.
lordship, because lordship, he has been given a notice only because of serving that notice 35 notice. That is not that lordship, he will be arrested, lordship. And today till date he is not arrested, lordship. So lordship may kindly allow us on Monday next, lordship, till only for 5-7 days, lordship. 5 days, lordship. We will bring the instruction as well as if required the city also.
We will appear, my lord. We will appear. We will cooperate, lordship. Now we should be given protection, lordship.
And counsel for the petitioner, also Mr. P.S. Lakar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners Mohammed Mukleshur Rahman and Shafi Kamal Ahmed, who are apprehending their arrest in connection of a case which may be registered on the basis of GD entry number 45/2026 dated 22/6/2026 of Borpeta Police Station. Learned counsel for the petitioner has submitted that the petitioners have been served with separate notices under section 35 within bracket 3 of BNSS by the police of Borpeta Police Station with a direction to appear before the investigating officer on 26/6/2026. Learned counsel for the petitioner submits that in pursuant to the notice received by petitioner number 2, he appeared before the investigating officer. However, he was detained in the police station for whole night and was subjected to torture. Subjected to torture?
Lordship.
Where is the statement?
My lord, I have given an annexer, my lord, kindly see.
No statement.
Page 10, paragraph 10, kindly see, lordship. Paragraph 10 of the, my lord, 10, 11, my lord, and 12, kindly see.
Where is torture?
Lordship, may kindly peruse the page 19 also, Lordship.
My lord, the annexer, lordship.
No torture. You just submitted that you were.
My lord, physically assault, lordship, paragraph 11, lordship, that may I read, lordship. During such detention, petitioner number 2 was allegedly subjected to intimidation, coercion, and physical assault.
Okay. Subjected to physical assault by police. And in this regard, he also lodged a complaint before Assam Human Rights Commission. It is further submitted by the petitioner, by the learned counsel for the petitioners, that the petitioner number 1 received the notice under section 35(3) on 26/6/2026 itself, and therefore he could not appear before the police on that day. And now they apprehend that, now the petitioners apprehend that if they appear, they may be arrested in connection with any case which might be registered on the basis of the aforesaid GD entry. Stop. On the other hand, yes, Mr. Locker, what you want to
Page
show?
19, Lordship. The petition number 2 appeared on 26 and he was allowed to go. Leave the station, Lordship. That is page 19, Lordship. Acknowledgement, Lordship. So, Lordship, when petitioner number 2 was not arrested, then why his apprehension is that he will be arrested, Lordship. That is the first paragraph, Lordship. Acknowledgement, Lordship.
On the other hand, Mr. P.S. Locker, an additional
So but here in this case, both
Public
the
prosecutor has submitted that in the instant case, only notice under section 35(3) of BNSS has been issued to both the petitioners, and the
This date is wrong, Lordship.
petitioner number 2 was allowed to be released, allowed to be released
My lord, 24. My lord, to suppress his detention all the night, my lord, it is,
On
that is given, Lordship.
26/7/2026. Stop. He further submits that there is no apprehension of the petitioners getting arrested, as it is not clear as to whether any police station case has been registered on the basis of the GD entry number 45/2026. Where is the GD entry?
GDNT, it is a notice itself, Lordship.
Mention
page 13,
about,
at first
no,
page. Page 13, Lordship.
stop. Let
Second line.
I have considered the submissions made by learned counsel for the petitioners. Let a report be called for from the officer in charge of Barpeta Police Station as to whether on the basis of GD entry number 45/2026 dated 22/6/2026, any police station case has been registered or not, and if so, the status thereof. In the meanwhile, the petitioner number 1 is directed to appear before the officer in charge of
Barpeta Police Station.
Barpeta Police Station in connection with the notice issued to him under section 35 within bracket 3 in connection with GD entry number 45/2026 dated 22/6/2026. Stop. If he is arrested in connection with
We put the notice.
any police station case which is registered on basis of the said GD entry, he shall be released on interim bail on furnishing a bond of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2, take from Abhishek. Let this matter be listed on 30 July for report.
Onwards. All like those.
30 July.
My lord, so far, my lord, the petition number 2, Lordship.
2 is already,
He has also been directed to appear, my lord, on 12/7/2026.
again,
My lord, 2.
petitioner,
when on first day he was appeared, he was allowed to go. He was allowed to leave the station. Lordship, again, Lordship, he may be called for.
Yes,
For
Lord.
that, Lordship,
I
where there
also
is
may
a
be
apprehension.
protected.
If
I
there
will
is no
appear, Lordship.
apprehension, then why there is
I also may
protection,
the
Lordship?
petition of 2 may
Petition,
also
that is
because he was
yes, he
tortured,
was not
Lordship.
appeared.
That is why.
He did not give allowed.
petitioner number 1 and petitioner number 2.
Lost.
Yes.
I beg apology, my lord. My lord, earlier item number 24, my lord, that UAPA matter, my lord. So, my lord, I made a mistake, my lord. My lord, while my lord looking in the section, my lord. So, as because my lord, that was a my lord pre-arrest bail application, my lord. My lord, that is my lord in
Bar is there.
yes, my lord. That bar is there, my lord, for pre-arrest bail, my lord. 438 application, my lord. And my lord, the Supreme
That
Court.
I was asking.
Yes, my lord. I
Where
made
is
that
the bar?
mistake, my lord, because that was for the my lord post-arrest, my lord, that section.
Where is the bar?
My lord, it is 43D4, my lord. Clause is 4, my lord. Yeah, okay. 4 to be made. Equal clause. কোনটো? দেখা আছে?
That bar is of 438.
Yes, madam.
438 is not there now.
Otherwise, I have informed the learned counsel. for
Let
the
him come.
petitioner That my lord, that law pen, I made a mistake. My lord, he just came out, but he said if it is fixed in the next half, my lord.
We'll take it up again at
Yes, at
Two.
2, my lord.
Two.
In the meantime, my lord, I will go through along with all the citations and all.
Okay.
And one issue, my lord, I was not wrong, my lord, referred to the my lord division bench regarding my lord, that is the my lord regular bill matter, my lord.
One
That, my
issue,
lord,
I'm not
yes, my
getting
lord.
it.
Some my lord guidelines is also framed, my lord. I will try to my lord find out that part also.
We'll take it up at 2.
My
Okay.
lord,
Item number?
my lord 24, my lord.
Item number 24, we'll take it up.
24. I have communicated him, but from the office side also, my lord,
Ramesh.
communication may be made.
Lawyer of phone calling nothing. Item 22, 24, lawyer of phone calling cover given. Without that, nothing. Okay.
Obliged.
The petitioner before your lordship is a computer assistant, was working as in block development office, Boruabari Development Block, lordship. FIR your lordship will find at page 80.
Page,
18.
yes.
Top portion, lordship, may I kindly note that date, lordship, that is overwritten. Page 18, top date is mentioned, 26. That has some relevancy. I will place before your lordship later on that date.
Yes.
With due respect, I, the block development officer, Borborua Development Block, Dibrugarh, hereby lodge this first information report regarding a serious case of financial irregularity and suspected misappropriation of government funds involving Sri Tonu Sunwal. He is the petitioner before your lordship, resident of Lejai Borborua, who is engaged as a computer assistant and was associated with the works of Bogibil Gaon Panchayat and Dulia Kakoti Gaon Panchayat. The matter came to light during the social audit and subsequent departmental verification of records. It was found that unauthorized IAY wage bills were generated in the names of beneficiaries whose IAY houses had already been completed and closed around the year 2017. Just here, I'm pausing for a moment that IAY is now, lordship, merged with Pradhan Mantri Awas Yojana in the year 2016 itself, 16 April. From 1st April 2016, that was merged with Pradhan Mantri Awas Yojana.
Okay.
Because here allegation is regarding Indira Awas Yojana. That is why I pointed out.
Okay.
During preliminary verification, it was detected that approximately 47 cases in Bogibil Gaon Panchayat and 115 cases of Dulia Kakoti Gaon Panchayat had been processed irregularly, involving a suspected amount exceeding rupees 40 lakhs. Further detailed examination may reveal additional such cases. It has also been revealed that the said transactions were allegedly made by entering details of unrelated or unauthorized job card holders instead of the actual beneficiaries of the houses. Consequently, government funds meant for genuine beneficiaries were diverted and transferred to other persons through unauthorized means. Although Sri Tonu Sunwal was no longer officially working in Bogibil Panchayat from December 2025, after another computer assistant was appointed, it has been found that the online processing of records from Bogibil Gaon Panchayat continued without the knowledge of authorization of the concerned Panchayat officials and staff members. During social audit and subsequent inquiries, statements were received from certain individuals whose accounts were involved in the transactions. They stated that they had assisted Sri Tonu Sonowal in withdrawing or collecting the amounts, though they claimed to have limited knowledge regarding the complete details and purpose of transactions. Preliminary evidence and relevant documents have been collected in support of the matter. Upon being questioned by the office regarding these serious irregularities, Sri Tonu Sonowal did not provide a satisfactory explanation and reportedly claimed that certain higher officials were also involved in the matter. Therefore, a thorough and impartial investigation is necessary to ascertain the entire chain of involvement, identify all all persons connected to the offense, and recover the misappropriated government funds. So this is the FIR. Now your lordship may kindly see page 21 because I have named in the FIR how they came to know my name, because there are the computer assistant who subsequently joined in my place clearly says that password is used by many persons, lordship. That your lordship will find page 21. May I read, lordship?
Yes.
To
No, no,
this
what you
was,
want to show?
lordship?
What you want to show?
Here, lordship, I want to show that the password of the computer was used by many persons of that office, and it cannot be ascertained who used those password to generate those bills. It is the computer assistant who initially informed the block development officer. That letter dated, lordship may kindly see 4/6/2026. And this is the reference given in the FIR also, that subsequent computer assistant who joined in that place, she initially detected those anomalies and informed the officers. So how she informed, that part lordship may kindly see. Last paragraph will do, third paragraph will do, lordship. It is pertinent to mention, lordship, okay.
Yes.
It is pertinent to mention that all computer assistants under Borborua development block were using the same computer password. Therefore, I am unable to ascertain who carried out these activities, since these transactions were executed without my knowledge or approval. So this password was used by many persons, lordship. And now if your lordship see the next page, that is letter dated 5/6/2026, that day, the next day of this informing the officials. Now who informed my names, lordship? Lordship may kindly see the signatories, that GRS, who is involved in selecting the beneficiaries, accredited engineer, who is involved in giving the completion certificate, the GP secretary, who is also involved in selecting the beneficiaries. They written a letter to the block development officer naming me as a culprit in the present case. Lordship may kindly see, with respect to the subject cited above, it has come to our notice that Sri Tonu Sonowal, how they came to know immediately after that incident, lordship, that is not mentioned. Sonowal, computer assistant of Dulia Kakoti Gaon Panchayat, has unauthorizedly given huge demand and transaction from financial year from 2023-24 to 25-26 during our tenure without our knowledge or authorization. Since these transactions were executed without our knowledge or approval, so I request your good office to kindly conduct a thorough investigation into the matter and identify the persons responsible. Now, immediately after that letter written by computer assistant. Now, here your lordship will find that at page 23, again the other persons who are also involved, they have also written secretary and other persons, GRS, other computer assistant, that computer assistant who is named, that letter I have shown.
No, but allegation against you is direct allegation.
No, I am coming to that, lordship. I have joined in the year 2020. And these allegations of generating beneficiaries of 2017. And now if your lordship see that, I'm just taking your lordship to page 26. This is the letter written by the block development officer, that is the informant, informing the chief executive officer. Here what he says, that in second paragraph your lordship will find that bills relates to 11 years ago. Second paragraph. That then it will be, lordship, around 2015. They do not have specific grounds on which date these were generated, when it was misappropriated. No specific date is there. They have named me, lordship, as an accused in the present case. And thereafter, lordship, after informing the chief executive officer, the chief executive officer authorized the BDO to file a case on 15/6/2026. Page 27, your lordship will get. page 15/6, 2026. Now immediately one FIR was lodged. Now what they did, Lordship, the police misplaced that original FIR. Thereafter, subsequently, their Lordship said that subsequently they have received the original FIR and accordingly forwarded to the jurisdictional court. That your Lordship will find page 28. Some anomalies are there in that aspect also. Because receiving the FIR, they have to send it immediately to jurisdictional magistrate so that there is no manipulation in the FIR. Page 28, your Lordship will find that IO has written to the CGM that original FIR was misplaced and therefore it could not be sent within 24 hours. Therefore, I have said that date is relevant. That 16 was manipulated and it was made 26. And the Chief Executive Officer authorized the BDO on 15th. And till date, he is not suspended by the department, Lordship. If anything he has done, they would have suspended him, Lordship. If any concrete evidence is there, nothing is there. Only that omnibus statement is there. Therefore, he is not suspended till date. And if he is arrested, he will lose his job, Lordship. Only for that purpose, I am paying for interim protection, Lordship. Lordship may consider the case diary and thereafter Lordship may decide. But till date, he has not been suspended. So on that ground also, Lordship may protect him. If they have the concrete evidence, they could have suspended me immediately, Lordship. I have made categorical statement that he has not been suspended till date, Lordship.
Regarding Lordship, that Lordship, page 22, Lordship, that is all the GRS Lordship and other persons Lordship have written that he is involved in that whole anomaly, Lordship. And at the same time, Lordship, the FIR page 2, second page, Lordship, that is also revealed, Lordship, that from the statements which received from certain individuals whose accounts were involved in the transactions, and they stated that they had assisted Sri Tonu Sunwal. So, Lordship, when persons whose accounts are involved,
Who assisted Tanush?
Lordship, that language may be different. Lordship, they stated that they assisted Sri Tonu Sunwal in withdrawing or collecting the amounts, though they claim to have limited knowledge regarding the
Without case diary, it is
So,
difficult.
Lordship, my learned friend has referred to a line, Lordship. Lordship, may I kindly continue that line?
Which
Claim
page?
to
Which page?
the page 19.
Page 19. Lordship.
Page 19. Second line he has referred. They stated that they had assisted Sri Tonu Sonowal in withdrawing and collecting the amounts, though they claim to have limited knowledge regarding the complete details and purpose of transaction. So they do not know the purpose of transaction. How they have informed, Lordship?
That is the Lordship. That is
If anything,
that is Lordship. That is the reason, Lordship. When persons do not know, because those funds were
anything-
for the beneficiaries, so they beneficiaries, Lordship. But when they themselves they are not the beneficiaries, so they do not know why their funds were transferred to their accounts, Lordship. So, Lordship, there and huge amounts are involved, Lordship, here in this case. Lordship, let the CD come, Lordship.
Case diary would be required.
otherwise, if he is arrested, he will lose his job. If case the material is there, Lordship can reject my bail application because my only ground is that, Lordship.
But
if-
now everyone is making allegation against you.
No, they are the persons who selected the beneficiary. Lordship, may I kindly see my ID?
Yes,
My
they may
ID.
be the person.
Lordship, I
but-
have joined the department in the year 2020. That page 13, your Lordship will
Yes.
find. And
Yes.
these are the allegations of 2015 and 17.
No, no.
No, yes, Lord.
In 2017, the
Beneficiaries were selected.
accounts were closed.
No, but if your Lordship kindly see page 18,
In the beneficiaries whose houses are already been completed and closed around 2017.
yes. If it is closed, that closed, Lordship, with the signature of the accredited engineer's completion certificate. Otherwise, it will not be closed. Because they have to give completion certificate by the accredited engineer, and the amount is given in 3 installments, Lordship. They have to cross each phase by showing photographs and other things. Then only the amounts will be disbursed. Otherwise, it will not be disbursed, Lordship. Amount is not given in one phase, Lordship. It is given in phase by phase in 3 phases. They have to give progress of that completion of house by producing photograph.
You are presently, where are you attached?
I am presently lordship in other lordship block and not in this block lordship.
Where are
It
you?
is mentioned itself lordship in paragraph page 18 last paragraph lordship. Page 18 last paragraph. I am not there lordship. No. He is no longer officially working in Bogibil Gaon Panchayat from December 2025.
That is why he may not be suspended also. And that may not be a ground for.
No,
sitting the
block
university,
development
as he
officer is the
not
head.
being suspended, so he may be allowed to go on.
I am in different block. I am in different panchayat, but block development officer is same. He could have suspended me. Panchayat may be
The
different,
purpose of investigation also.
but block development officer is same.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. P. S. Lakar, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Tanuj Sonowal, who is apprehending his arrest in connection with Barbarua PS case number 43/2026 under section 316 within bracket 5/318 within bracket 4/336 within bracket 2/340 within bracket 2/61 within bracket 2 within bracket small a/3 within bracket 5 of BNS read with section 13 within bracket 2 of Prevention of Corruption Act 1988. The gist of accusation in this case is that on 26/6/2026, the block development officer of Barbarua Development Block, Dibrugarh, had lodged an FIR before the officer in charge of Barbarua Police Station, inter alia, alleging that that serious financial irregularities and suspected misappropriation of government funds by the petitioner Tanu Solvan, who was engaged as computer assistant. Where you were engaged earlier?
Earlier, I was engaged in Bogibil Gaon Panchayat and Dulia Kakoti Gaon Panchayat. Now he is no longer in Bogibil Gaon
Bogibil
Panchayat.
Gaon Panchayat and Dulia Kakoti Gaon Panchayat. Has come to light during social audit and subsequent departmental verification of records. It is alleged that unauthorized Indra Awas Yojana wage bills were generated in the names of beneficiaries whose IAY houses had already been completed and closed in the year 2017. It is suspected that financial irregularity to the tune of rupees 40 lakhs is involved in this case. Learned counsel for the petitioner has submitted that the petitioner is presently working as a computer assistant in Bogibil Gaon Panchayat. No,
Earlier here.
where are you working now?
Now Lordship that Dulia Kakoti Gaon Panchayat.
In Dulia Kakoti Gaon Panchayat. And the accusation made against him in the FIR are not true. He submits that it is apparent from the letter dated 4/6/2026 of the present computer assistant Bornali Yen YEIN of Bogibil Gaon Panchayat, who has first flagged the issue of unauthorized wage demand bills made in respect of Indira Awas Yojana. Stop. Learned counsel for the petitioner submits that the in the aforesaid letter dated 4/6/2026, it has been clearly mentioned that the computers used for generating the bills had passwords, and all the computer assistants under Barbarua development block were using the same computer password, and therefore it is unable to tell as to who carried out these activities. He submits that later on, though the what is meant by GRS?
Lordship is referring to
Page 22.
22.
Dulia Kakoti.
DRS.
Three informant. Page 22.
GRS, Gram Sevak, it is from GRS, yes, Gram Sevak, probably. GRS or full form to this person. Yes, Gram.
He further submits that in the
Yes, sir.
letter addressed to the block development officer on 5/6/2026, though accusation has been made against the present petitioner, however, no basis of that accusation has been spelled out there. He further submits that the petitioner is presently working as computer assistant and has not been put under suspension, and he is ready to cooperate in the investigation. However, if he is arrested, his he is arrested in the aforesaid case, his career may be jeopardized. And therefore he prays for granting interim anticipatory bail. On the other hand, Mr. P.S. Lakarl, an additional public prosecutor, vehemently opposed grant of any interim protection at this stage. He submits that there are categorical accusations made against the present petitioner in the FIR, and hence, without perusal of the case diary, the veracity or otherwise of the allegations cannot be ascertained at this stage. Anything else?
Page 26, Lordship, second paragraph, Lordship, may kindly pay Lordship. That his involvement, how he is doing, Lordship. Works were over in the year 2017, but he is newly generated the bill, Lordship. That is, Lordship, page 26, second paragraph. It has been found that the computer assistant promotional, without the knowledge, approval, or information of any concerned officials or staff members of the respective Gau Panchayat, had already generated IAY wages bill over the last several months in the name of beneficiaries whose house has already been completed approximately 11 years ago. Sorry, 11 years. So he has now, he has generated the bills which has, the work has already been done. So Lordship, his involvement is very much clear, Lordship.
He further submits the that the accusation made against the present petitioner are categorical in as much as he, without the knowledge, approval, or information of any concerned officials or staff members of the respective Gaon Panchayat, has generated Indra Awas Yojana wage bills over last several months in the names of beneficiaries whose houses have already been completed approximately 11 years ago. Case diary would be necessary.
No, here it is said 11 years already I have pointed out, but in the FIR it is said in the year 2017. So if it is 15 or 17, they have no concrete proof to that. On to that context, I have said submitted before this honorable court. Because of that, Lordship, if they do not have any concrete evidence, they have not suspended me. That is what I have pointed out before your Lordship earlier.
This is only
Because
FIR.
there has to be.
Suspension is different matter.
No, Lordship, what my submission to your Lordship is that they are in FIR, they said that the houses were completed in the year 2017, page 80. And in page 26, they are saying that houses were completed approximately 11 years ago.
You
If it
take
is
any case.
Lordship.
What is your defense? Your defense is that
My defense is
you
that
have not
first-
done it.
No, my first.
Some other computer assistant.
Yes, may have, because Lordship, the computers which were in
This can easily be verified during investigation.
this can be verified, but they have not verified. What my submission to your Lordship is that on fourth Lordship, computer assistant says that someone has misappropriated, and that it cannot be ascertained because the password is used by many persons from the earlier point of
No,
time.
when the password, when the transaction is made in the computer,
That has not mentioned anywhere.
That
Lordship.
is also.
That is not mentioned.
He has
Lordship.
generated
That
the
is
bill.
what
no, that is not mentioned here,
Here,
but in investing, in CD it will be there.
it is CD will be there, but for that I am praying for protection, Lordship. Because no specific date is there when it was generated.
If required,
When it was generated.
on Monday, I will be in the city, Lordship.
No, when it was
Not-
placed, Lordship, when it was released,
not
no
reopening.
specific date is mentioned.
Monday, Lordship. On Monday, I will be in.
And in fact, they have not mentioned that.
Last line. Let me stop. After considering the contentions raised by learned counsel for the both sides, this court is of considered opinion that perusal of the case diary.
In that case, may I pray, Lordship, that if he is seeking for short date, Lordship, that interim prayer may be kept open, Lordship. Because they may not bring on Monday, Lordship. In that case, I will be prejudiced.
That is where Lordship.
If they can bring, it is okay. If they cannot,
Days.
yes.
13, Lordship.
Would be necessary for consideration of the instant bail application. Hence, call for the case diary. let this matter be listed on 13/7/2026. The option of
If they fail to bring case diary.
option of consideration of the interim bail, consideration of prayer for interim bail is kept open. Stop. List accordingly.
Obliged.
Made please, your lordship. This is an interim bail application. Apprehension arises out of notice at page 24, my lord. This notice is to the petitioner. My lord will see that there is no mention of any FIR or any provisions. Only on the basis of a complaint petition submitted by Amol Chandra Kolita. So, my lord, what is the petitioner's relationship with Amol Chandra Kolita? My lord will see at page 9. Page 9, my lord, with his wife, there was a development agreement. The petitioner, my lord, is a builder, and the wife of this alleged complainant is, my lord, the landowner. So the petitioner was supposed to complete a project and hand over a share of the flats to wife of the said person, my lord. Now the project is progressing, but the wife of this person is demanding cash. She's saying she does not want the flats anymore. She's demanding cash, and which is contrary to the development agreement, my lord. And because the petitioner is not acceding to those demands, my lord, somehow through
Where is the notice?
a notice is at page 24, my lord.
When you have to appear?
On 10th.
10th, my lord.
You appear on that day.
Some protection may be given, my lord.
Heard Mr. What is your name?
I bought her.
Heard Mr. I Bhattacharya, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Vivek Chowcharia, who is apprehending his arrest in connection with a notice received by him under section 35 within bracket 3 of BNSS from the Assistant Commissioner of Police, Jalakbari Division. Learned counsel for the petitioner submits them. Though the notice under section 35(3) within bracket 3 BNSS has been received by him, indicates that he has to appear before the Assistant Commissioner of Police, Jalakbari Division on 10/7/2026. However, it only indicates that the said notice has been sent to him on the basis in connection with a complaint lodged by one Amal Chandra Kalita. However, there is no indication as to whether any case has been registered in pursuant to the complaint filed by Shri Amal Chandra Kalita or not. Hence, he apprehends that if he appears before the Assistant Commissioner of Police, Jalakbari Division, in pursuant to the aforesaid notice, he may be apprehended. Stop. On perusal of the notice annexed along with the notice under section 35 within bracket 3 annexed along with the bail application, it appears that it indicates no case number in connection with which the said notice has been issued to the petitioner, though it does indicate that it is in connection with some complaint filed by one Amal Chandra Kalita. Stop. Let a report be called for from the Assistant Commissioner of Police, Jalukbari Division, Gauhati, as to whether any case has been registered in connection with the complaint filed by Amal Chandra Kalita or not in Jalukbari Police Station. In the meanwhile, the petitioner shall appear before the police in terms of notice under section 35 within bracket 3 dated 29/6/2026, received by him, on the date fixed, that is 10/7/2026. Stop. However, if on the basis of the complaint, if in the meanwhile on the basis of the complaint filed by Shri Amal Chandra Kalita, any police station case is registered and the petitioner is arrested therein, arrested in connection with the said case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. Let this matter be listed on
21st
21st for report.
July.
Case is there.
Yes.
A person is made and accused in a UAPA case
Yes.
where materials does not indicate involvement of any
Minor.
offense, then that bar may not operate.
Exactly, Your Lordship. That is the only thing, Your Lordship. And
So
My lord,
you are withdrawing or what? What is your submission?
the prima facie thing only in NI versus Jahur Ahmad Shah Watali, I'll give a copy, Your Lordship, that regarding what is prima facie
No, today
in
I'll
NI
not go
cases,
into
that
this.
is also given, Your Lordship.
So what is your submission?
So let the case diary come, Your Lordship, if there is no
Then
prima facie material,
interim protection you may not get.
I am not entitled. That I agree.
So we are not.
my lord, my respectful submission is that, my lord, I'm just, my lord, very, my lord, short, my lord, one, my lord. Patience, my lord, I'm relying, my lord.
Anand, tell.
Yes, my lord. That case is also, my lord, related to, my lord, that is the PRS bail applications, my lord.
Yes.
Here, my lord, Honorable Supreme Court stated, my lord, we have not mentioned the facts in details as requested by learned counsel. However,
No, but
we-
it does not. My query is in a case
my lord,
involving UAPA.
yes, my lord.
Suppose there is no material, prima
Yes,
facie
my lord.
material.
My lord, remote prima facie, my lord. My lord, in my lord, coordinate, my lord, High Court of my lord, Kerala, my lord.
Yes.
They in one of the, my lord, matter, my lord.
What it says.
My lord, relevant paragraph is, my lord, 15 and 16, my lord. After this, my lord, order, my lord, that is also, my lord.
Then we'll fix it for hearing on the question of maintainability,
On the
calling
maintainability, my lord.
calling for the case diary on the next date without any interim.
My-
That
Lordship.
interim I will remove
Yes, yes.
and his objection I will reflect it in the order,
Yes, my lord.
and question of maintainability shall be decided on the next day.
Lordship.
My lord, my lord.
Lordship.
My lord.
Lordship. I also come prepared. on that.
Date will remain same.
My lord.
Yes.
My lord.
Okay.
It took 2024, sir.
I'll dictate that part in chamber
My lord.
Lordship. Lordship.
because dictation has already been given.
Obliged.
Lordship, my only prayer is can the date be preponed, your Lordship, to 18th or 19th?
Okay. Some 18th. 18/7.
18/7.
18/7.
Meenakshi Kovamu dictation.
Obliged, Lordship. I also didn't go to the section, otherwise I would have
Yes.
fairly submitted your
No,
Lordship.
you make your submission on next day.
Lord. Obliged, Lord.
Updated again 44.
My lord, he has to catch the flight at 5 o'clock, my lord. That's why, my lord, we are giving. I am here, my lord.
Yes.
Anyway, when I say writ petition, my lord, I am challenging the temporary settlement of the, my lord, respondent, private respondent, my lord. It is regarding, my lord, settlement of the cattle market. So, my lord, your lordship kindly see the regarding temporary settlement, the position is very clear and our High Court judgment is also very clear in this regard, my lord. Your lordship kindly see page 18, my lord.
No, which order you are repealing?
I am, that is 72, my lord, page 72. Page 72. Temporary settlement for the year 26-27. Has your lordship get it, page 72, my lord?
Yes.
Page 72, my lord. Temporary settlement for the year 26-27. Name of the market, Tangani, Soyens cattle. Dear sir, with reference to the subjects, this is the information that the General Standing Committee meeting dated 3/6/2020.
It has been settled in the name of previous lessons.
Previous lessee heard until further order. That cannot be done because of the High Court order as well as the own circular of the government. That I'll come to that, my lord. Very next page, my lord, page 71.
Now what is to be done?
My lord.
What is to be done?
Now, my lord, as per 105 of the Panchayat Act, it is directly run by the Zilla concerned Panchayat, my lord. Or who says me, my lord, Panchayat, Anchalik Panchayat or Zilla Parishad. If it is less than 5 lakhs, Gaon Panchayat, is more than 10 lakhs, that is up to 10 lakhs, it is Anchalik Panchayat. And my lord, it is since it is more than 10 lakhs, it will be, my lord, Zilla Parishad. So that is it. By applying rule 1055.
What is 1055?
Before that, my lord, your lordship, I just want to place one thing, my lord, that page 18, my lord, your lordship kindly see. Earlier, as a cabinet decision taken, my lord, that during that transit period, that for temporary settlement, it will be goes to the previous lessee until further. That decision was challenged before this honorable court, and this division, this single bench judgment, which has not been challenged so far, my knowledge goes to the before the division bench. Probably my lord, I have finished to know. That was decided and that portion has been, my lord, deleted. This regarding temporary settlement, you can, it is by exercising the power 105, it will be by the Panchayat directly or Jilla Parishad directly, not by the any lessee. That page 18, my lord, that your lordship kindly first page up, my lord.
Yes.
Yes. Pursuant to the decision of the meeting that
This has been challenged.
challenge and this judgment has been passed and findings, my lord, your lordship, page 59. Page 59, your lordship finding. Page 59. Page 59, your lordship kindly see. Para 37. Has your lordship got it, my lord? Page 59.
Just a minute.
Yes. Clause number 30, para 37, 2. The impugned cabinet decision dated 27/6/2024, as well as the impugned notification dated 29/6/2024, in so far as granting extension to the existing licit till new tender are not issued, run counter to section 105 of the action 1994, section 22. As such, the impugned cabinet decision dated 27/6/2024, as well as the impugned notification dated so and so the extent are interfered with. 2. 3. The respondent authority are directed to run the HAT in question till finalization of phase tender under this direct management of the concerned Anchalik concern. So that
Who will collect the tolls?
by engaging own man by the Panchayat, my lord. Jilla Parishad.
Provision is there.
Yes.
No.
1055.
No, 1055. What?
And also, my lord, there is very recent, their notification is also very clear. Strictly, there has to be followed. 105.
their own notification, my lord. Probably that is ignoring that, my lord, that the impugn order is issued. Page 71A. The condition. In fact, I quote the 71-1055, I have quoted in the petition, my lord.
No, which authority will run the market?
Now, my lord, it is the Zilla Porishad, my lord.
Dorong Zilla Porishad.
Dorong Zilla Porishad. Because if it is not challenged, my lord, they will continuing this, my lord, one by one, another one after another year, my lord. In fact, another judgment also, my lord, similar line, my lord.
Now, Darang Jilla Parishad will collect the,
Tax collectors are.
They are collectors, yeah.
they don't have they have their own collectors. Then what is the necessity of tendering it otherwise?
To earn more revenue, my lord, because directly
No,
sometimes.
if we direct the Darang Jilla Parishad to collect the
As per
toll,
105.
105.
and if they don't have men to collect that, then the state exchequer will suffer loss.
My lord, they can engage person, my lord, to collect
Contact
the
basis.
revenue.
How they will engage?
They can, on contract basis, they can engage to only collect. But this settlement was, my lord, not to collect, my lord, but as a temporary settlement that was given.
Okay. Heard. Mr. T.J. Mahanta, Learned Senior Counsel assisted by Mr. B. Rahman, Learned Counsel for the petitioner. Also heard Mr. What is your name?
My lord, as Datta for 1 and 4, my lord.
S. Datta, Learned
Standing counsel, PNRD disaster.
Standing Counsel. PNRD Department. Appearing for
Respondent number 1 and
respondent number 1 and 4. Also heard Mr. What? S.S. Chaudhary.
Roy.
S.S. Roy. Appearing for respondent number 2. Who is for 3?
My lord, 3 and 5 notice may go, my lord.
Stop 3. This writ petition under Article 226 of the Constitution of India has been filed by the petitioners. Petitioner Hanif Ali Ahmed, impugning the order dated 1/7/2026 by which the Chief Executive Officer of Darang Jilla Parishad has allowed the ex-lessee to run the Tangani weekly cattle market at lowest rate as an interim arrangement till it is finally till the settlement of the said market. Stop. Learned Senior Counsel for the petitioner has submitted that the order dated 1/7/2025 issued by the Chief Executive Officer Darang Jilla Parishad Mangalde is whereby the temporary settlement of Tangani cattle market was given to the previous lessee at the rate of previous settlement value within bracket 2023-2024 is in violation of statutory provisions contained in section 105 of the Assam Panchayat Act 1994. He submits that earlier there was a notification by the notification dated
29/6/2024.
29/6/2024 issued by the Principal Secretary to the Government of Assam Panchayat and Rural Development Department, which allowed such temporary settlement until new tenderers are finalized. However, However, he submits that a coordinate bench of this court, by its judgment dated
29/11.
29/11/24.
29/11/20, 29/11/20,
24.
2024,
Page 40.
passed in writ petition number 5993 slash
There are various writ petition, my lord.
2024
Only one. And others.
has and similar other writ petitions have set aside the said
Said portion only, the notification on that portion only regarding extension.
notification
Regarding extension part.
regarding
Page
regarding
59.
so far as granting of extension to the existing lessee till new tenderers are finalized, as same runs counter to the section 105 of the Act of 1994, as well as Rule 47 of the Rules of 2002. Stop. Issue notice to the respondents. Since respondent number 1, 2, 4, 1, 2, and 4 are represented by learned government councils, no formal notice need to be issued to the said respondent. You have received the copies?
Well,
Extra copies?
they will serve that.
The petitioner is directed to serve extra copies of the writ petition along with annexures to the learned government council for respondent number 1, 2, and 4. However, as regards respondent number 3 and 5, the petitioner shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on August, 5th of August. Stop. You want interim?
My lord, I want interim.
In the meanwhile, considering the submissions made by learned senior counsel as discussed in the foregoing paragraphs, the operation of impugned order dated
1/7.
1/7/2025 bearing
26.
May 2025.
26.
26.
26. Yes.
Okay, you have typed out wrongly.
Yeah.
2026 bearing memo number DZP Bajar/Bazar/1313/
Sorry, no, my lord, your lordship, page 72. Impugn order is page 72, my lord.
That was earlier, right?
And that was earlier, my lord.
No, you have not given typed copy.
Oh, page 72, my lord.
Annexure F.
Annexure F. Original copy is there.
It is dated,
That is 1/7/2026.
yes, Abhishek. नहीं वो काट दीजिए. Impugn order dated 1/7/2026. Bearing memo number ECF 221100/448 of the Secretary to the Government of Assam, Panchayat and Rural Development. This for, yes,
Impugn note has been issued by the Chief Executive Officer, Dorok Jilla Police. It is
Page 72,
page
my
70
lord.
is not here, my lord. 71A and B, that is, my lord, the
That is
government
government
notification.
notification. That is been violated also.
sorry. Impugn order dated
26.
1/7/2026, bearing memo number DZP/Bazaar /1461
240.
/240, issued by the in-charge Chief Executive
My lord,
Officer,
that's the problem.
Darang Jilla Parishad Mangalde, shall remain stayed. During the period of operation of stay order, the above mentioned market is directed to be run by whom?
Run by, as per provision of 105. 1055.
Run by the
Concerned Jilla Parishad.
concerned Jilla Parishad.
As per
per
provision of
the-
1055.
As per the provision of section 105 within bracket 5 of the Assam Panchayat Act 1990.
My lord, as amended.
List accordingly.
My lord, that is my claim. Deep look.
I'm good.
Thank you.
Wait, please, your lordship.
Yes.
Pre-arrest bail application, lordship. We have three petitioner before this court, lordship. Petitioner one is the husband and the other two are the brother of this petitioner number one, and three is the wife of the petitioner number two, lordship. FIR, lordship, will find on page 13, lordship, the vernacular on page 16, lordship. May I read, lordship?
No, what is the offense?
Offense, lordship, dowry debt, lordship. What happened, lordship? This petitioner, lordship, as per FIR, lordship, 80,000 was demanded 1 year ago, lordship. That amount was paid, lordship. Subsequently, they have demanded, subsequently demanded by this petitioner number one. As per allegation, lordship, she was tortured, lordship. Later, lordship, she consumed poison, lordship. This is the allegation, and thereafter she was taken to the CHC hospital for treatment. The doctor referring her to send GMCS, but this petitioner, lordship, without taking her to the GMCS, lordship, they taken her to their home, lordship. So that is on the next day, lordship, when she was taken to GMCS, she expired, lordship. Now this informant, lordship, suspected that it is specifically stated, lordship, they are strongly suspected that this accused person killed her, lordship. That is the allegation, lordship. No specific, they said, lordship, 1 year ago, 80,000 was demanded, that was paid, lordship. Regarding allegation against 2 and 3, against the petition number 2.
What is the date of marriage?
Marriage, lordship, 2021, this petition number 1 got married with this informant sister, lordship.
Yes. CD will be.
Lordship, against this, lordship, 2 and 3, there is nothing in the, no allegation,
Who
lordship.
is 2?
2 is the brother and wife of the brother, lordship. 3 is the wife of the brother of the petition number 1.
Allegation is that person accused of 2 and 3 jointly harassing my sister since the date of the
No
heartbreak.
specific, lordship.
So that will come even in the city lawsuit.
Only against husband.
We'll
lordship.
fix short day.
So kindly protect these two petitioner because they are lordship decided separately, lordship.
Separately,
In the same compound, but lordship, the specific allegation against the husband, lordship. Husband has demanded 80,000, lordship. It is not said that has been demanded by the other petitioner, lordship.
but the allegation is against you. Both of you are.
But lordship, the dowry, lordship, it is They have a,
CD.
Lordship, since
Not
is that-
Mr. B. Chaudhary, learned counsel for the petitioner. Also at Mr. P.S. Locker, learned additional public prosecutor. Considering the nature of a accusation leveled against the present petitioners in the FIR,
they
perusal
suspected, Lordship. It is stated in
perusal of the case diary would be necessary. Hence,
FIR says suspected, Lordship.
call for the case diary. Let this matter be listed on
Lordship,
13th.
against this Lordship 2 and 3 kindly be protected, Lordship. They are no Lordship, only specifically against husband, Lordship. Demanded 80,000 by the husband, Lordship. That was demanded 1 year ago, Lordship. And she consumed poison, Lordship. Till Lordship, case diary, Lordship, if any adverse come, Lordship may reject my bail petition, Lordship. Let this petition be appear and Lordship record their statement.
Where is the vernacular?
Vernacular, that is on page 16, Lordship.
Against you also.
Manusik Nirjatan physical, no specific Lordship. What is
After
but Lordships are
we are fixing it on 13. Let this matter be listed on 13.
obliged.
13. On Lordship. This is on A17 Lordship.
Only case
28.
13th.
13.
One.
15 Lordship, 13 income Lordship. On 15, 14 Lordship.
Okay, 14.
Yes,
Yes.
please, Your Lordship. FIR is at page 10, Your Lordship. May I read, Your Lordship?
Yes. What is the offense?
Offense under Immoral Trafficking Act, Your Lordship. Allegation, Your Lordship. I beg to inform you that we have come to know that there has been some immoral activities being carried on in Rajmahal Hotel, situated at Bapuji Nagar. It is with much sadness that we beg to inform you that today, that is on Sunday, 28/6/2025 at around 11 o'clock, we had gathered with the local people at court 100 boys and girls engaged in immoral activities in room number 101, 102, and 103, and accordingly informed the administration. Then we checked the registration book and found that there was no boy's name registered against the room number 102. The incident has degraded the social environment of the Goalpara. Accordingly, we request you to take appropriate action against the proprietor and the other staffs of the hotel. Your Lordship will kindly see, based on this, they have registered the case under section 61(2), 143(3), and 144(2), along with 3 and 4 of Immoral Trafficking Prevention Act, Your Lordship. Now, on the face of it, Your Lordship, this will not come, Your Lordship. And before that, Your
Which
Lordship.
will not come.
Lordship.
Which will
143, 144, there is no question of immoral trafficking, Your Lordship. They, as per the definition, if we go by the definition of the trafficking, Your Lordship. Now, Your Lordship will kindly see, I am the owner of the hotel, Your Lordship. I have taken it on lease from someone, Your Lordship, from the government, Your Lordship. With trade license, I am running it. And on the basis of this affair, case has been registered and the manager has been arrested. Your Lordship will get the forwarding at page 16, Your Lordship.
Yes.
Now, Your Lordship will find ground of the arrest of so and so. There, Your Lordship, these are general. Your Lordship will kindly see from 1 onwards that informant, namely so and so, along with 11 numbers of local public laws and written FIR before the officer in charge Goalpara Police Station, alleging that antisocial and immoral activities involving college-going girls, students were being systematically carried out in hotel so and so. That on 28/6/2026, about 11 p.m., upon a surprise visit conducted by the informant party, room number 10, 102, and 103 of the said hotel were found occupied by girls and boys in a compromising and inappropriate condition, indicating the active facilitation of immoral activities in the hotel premises under the direct supervision and control of the arrestee as its manager. Essentially, Your Lordship, allegation against the manager. Now, the upon verification of the guest register maintained at the hotel, it was found that room number 102 had not been allotted or booked in the name of any male occupant, despite a male person being found present therein, thereby establishing deliberate concealment, falsification, and non-maintenance of mandatory guest records of the arrestee, which is statutory obligation cast upon the persons in charge of the hotel management. That during the course of investigation, you may recovered incriminating unusual materials from room number 101 of the hotel, including used condoms, anti-condoms, packets, beer bottles, and cigarettes, which corroborate the allegations that hotel premises under the arrestee's management were knowingly used for immoral and antisocial activities. That further scrutiny of the guest register, multiple repeated entries in the name of some female victims, accompanied on each occasion by different male persons by on date so and so, which establishes clear and continuing pattern of misuse of the hotel premises, which the knowledge, these are the, your lordship, the allegation. Now your lordship will kindly see, number one, your lordship, is this, your lordship, that I am not, I have not been, you know, involved with the day-to-day management of the hotel, your lordship. That has been done by the manager, as has been stated in the ground of arrest itself, your lordship. That is, apart from that, your lordship, it is not their case that these are minor, you know, people, your lordship. Some women, some adult people have come to the hotel, they entered the guest rooms, your lordship, and what they do within the surroundings of that room, it is their private affair, your lordship. How can I control that, your lordship? And the cigarettes, beer bottles within the private premises, your lordship, can this be an activity, your lordship, immoral activities? And where are the materials, your lordship, to say at least that there is a trafficking? For trafficking to be attracted, your lordship, then the word itself says, your lordship, there will have to be, your lordship, transportation from somewhere to some place, harboring, then there will have to be use of coercion. That is what Honorable Apex Court has held in 2025 judgment, your lordship, that what amounts to trafficking. No, some people come, your lordship, adult people come, the room has been booked, and on the basis of that, they are staying there. How can I be fall for that, your lordship?
What is 61?
61, your lordship, conspiracy, your lordship. And raised, your lordship, 145, your lordship may kindly see 145.
145 is 144 and
144, your lordship.
Okay, it is not.
Let your lordship CD may be called for, and in the meantime, your lordship, this man
Lordship.
may be protected, your lordship.
Yeah, in this case, Lordship, Lordship also may kindly come to page 17, para 4, last bail objection prayer 4, that the victim involved in the present cases are college-going girl students. So, Lordship, we do not know from reading the affair, we cannot say, Lordship, whether they are minor girls or major girls. And apart from that, Lordship, it is not that, Lordship, there's some hotels are some license has been given to open a dhaba or hotel, Lordship, for doing some immoral activities. That is the immoral act, Lordship. If some girls and boys are entered into a room, private room there, and some questionable objectionable materials are found. What found that has been already been read by my learned senior counselorship, that what has been found. If those articles are being found in that room, then what does it mean, Lordship? And it is not that, Lordship, the owner do not know. And this is the register. The owner will definitely know how, because some particular room has been allotted to some persons who in fake name, Lordship, using fake name. So, Lordship, at this stage, Lordship, let the CD come. Thereafter, Lordship will examine, Lordship, whether he is involved or not. Because, Lordship, his involvement is clearly reveals in this case, Lordship. And nowadays, Lordship, this is a common thing, and it ruins our society also, Lordship. At the same time,
Society is ruined, your lordship. That is not the point. The legal submission, your lordship.
They are being allowed that they are measured, even they are measured, they will do anything, Lordship.
They will do anything. That's the law.
They have got. This is not a brutal, Lordship. Whether they have been allowed.
Heard, Mr. P. Bhattakur.
Yes.
Sorry, S. Bhattakur. Learned Senior Counsel assisted by Mr.
US Bora.
U.S. Bora. Learned Counsel for the petitioner. Also Mr. P.S. Laukar. Learned Additional Public Prosecutor. This application under Section 482 of BNSS has been filed by the petitioner Habil Uddin Khan, who is apprehending his arrest in connection with Gwalpara PS case number 113/2026 under section 61 within bracket 2/143 within bracket 3/144 within bracket 2 of BNS read with section 3/4 of the Immoral Traffic within bracket Prevention Act 1956. The gist of accusation in this case is that on 29/6/2026, one Nabajoti Dha. Nabajoti, what is the name of the first?
Rekka, Nobojoti Dhar, your lord. Dha, your lords. It says Dha. A para page 12, your lords. This is the gist of the first information report recorded by the police.
Nabajoti Dha and
Dha to ki upar hai?
11 others filed an FIR for the officer in charge of Gwalpara police station, inter alia alleging that on coming to know that immoral activities are carried out in Rajmahal Hotel situated at Bapuji Nagar, Gwalpara, a raid was made in the said hotel at about 11 o'clock on 28/6/2025, and during that raid, boys and girls engaged in immoral activities in room number 101/102 and 103 of the said hotel were caught red-handed. Stop. Learned counsel for the petitioner submits that petitioner is the owner of the said hotel and he has taken that hotel on lease. He submits that the petitioner, being the owner, is not involved in day-to-day management/activities of the said hotel, and he was unaware about what was going on inside the rooms of the said hotel after said rooms were let out to the customers. He submits that the manager of the hotel has already been arrested and the petitioner, being the owner of the hotel, is ready to cooperate in the investigation. However, he is apprehending that he may be arrested at any time in connection with this hotel, in connection with the offense alleged in this case. Learned counsel for the petitioner further submits that bare perusal of the FIR would indicate that since college-going girl students were involved, it is not a case of trafficking under section 143 or 144 of the BNS or under section 3 or 4 of the Immoral Traffic within bracket Prevention Act 1956. He submits that in any view of the matter, the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor Mr. P.S. Lakar has vehemently opposed the grant of any temporary relief to the petitioner at this stage, considering the nature of the offense involved in this case. He submits that the offense involved in this case has a repercussion in the society, and unless the case diary is produced, no relief should be granted to the petitioner. Anything else?
And he is the owner, lordship, so he cannot shift this burden enter to the manager, lordship.
Further submits
Like
that
he is
as the
available.
petitioner is the owner of the hotel where alleged offense was committed, he cannot shift his responsibility once immoral activities are found to have been committed in the said hotel. Stop. I have considered the submissions made by learned counsel for both sides. Let the case diary be called for. Let this matter be listed on 24th of July. In the meanwhile, considering the fact that the manager of the hotel has already been arrested and the submissions made by learned senior counsel that owner may not be required to be informed in day-to-day activities of the said hotel, the petitioner is directed to appear before the investigating officer of Golpara PS case number 113/2026 within 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of rupees 50,000 with interim bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the arresting authority. List accordingly.
Deeply obliged.
May I please, your lordship? This is a previous bail application, lordship. That the case is registered, lordship, under section basically 196, 118, 109, and 308, lordship.
What is 196?
196, lordship, promoting enmity between different groups of people, lordship, and 118 is causing grievous hurt, and 109 attempt to murder, and 308 is extortion, lordship. But the FIR will find page 25, lordship. That the informant is, lordship, the Sri Amarendra Lokpal, lordship, who is the chairman of the Rongia Municipal Board, lordship.
Where is the FIR?
FIR page 25, lordship. And in the FIR, lordship, the 9 persons named in the FIR.
Who are you?
I am for accused number 1, lordship, who is the owner of the Rudramani Dhaba, lordship, where the occurrence took place, lordship. And lordship, accused number 2, 3, 4, and 8 and 9, lordship, already preferred a bail application before this honorable court in coordinate bench, lordship, order that will find, lordship, page 44, lordship. Granted interim bail, lordship, page 44, lordship. And
When is this?
accused number 2, 3, and 4 are brothers of accused number 1, lordship.
When is the CD? Case is fixed.
Lordship, fixed on, lordship,
29.
29/7/2026, lordship.
Yes,
They
Mr.
are on interim, lordship.
Yes, Mr. Bosho, anything?
Set of the co-accused is my lord granted interim protection.
Heard Mr. I.U. Chaudhary, learned counsel for the petitioner. This also heard Mr. K. Bosho, learned counsel, learned additional public prosecutor. This application under section 482 of BNS S 2023 has been filed by the petitioner Jainur Ali, who is apprehending his arrest in connection with Rangya PS case number 143/2026 under section 61 within bracket 2, 196 within bracket A, 1 within bracket small a, /118 within bracket 2, 109 within bracket 1, 308 within bracket 5 of BNS 2023. The gist of accusation in this case is that on
Page 45.
on 9/6/2026, one Amrendra Lakar had lodged an FIR naming 9 numbers of accused therein, including the present petitioner, alleging that petitioner number 1 has put some photos of deities of Hindu religion in his hotel, and when the informant asked him to remove the same, he did not do so. Whereupon an argument ensued between them, and as a result of which the informant sustained injuries. Learned counsel for the petitioner submits that the allegations made against the present petitioner in the FIR are not true. He further submits that in the meanwhile, how many accused?
Lordship, in the FIR, 9 persons, Lordship.
How many have been?
5 persons.
In the meanwhile, four co-accused persons have already been granted.
5 persons, Lordship.
Who 5?
5. Another order, Lordship, page
5.
5, Lordship.
5 co-accused persons have already been granted interim bail by coordinate benches of this court, and in one of the case, namely AB 1519/2026, whereby 4 of the co-accused were granted bail, case diary has been called for fixing the matter on 29/7/2026. He therefore submits that the petitioner, who stands on same footing as that of the co-accused persons who are already on interim bail, may also be given interim protection. Stop. Learned additional public prosecutor also prays for calling of the case diary. Let the case diary be called for. Let the matter be listed again on 29/7/2026. However, in the meanwhile, the petitioner is directed to appear before the investigating officer of Rongya PS case number 143/2026 within 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2, list accordingly on 29/7/2026.
Deeply observed.
So in this, I will be allowed to withdraw the cases.
Third, Mr. N.J. Gogoi, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Obliged.
Show the name of K. Bush also. Additional.
Obliged.
May I please, Your Lordship? Prior to coming of FIR laws against us, I may allow to read the FIR laws by us, Your Lordship. Kindly please 30, Lordship. Particular at page 30, Lordship. May I read, Lordship?
Oh, where is the FIR against you?
That is at page 20, Lordship. Lordship, FIR lost by us, we lost the FIR on 2/6 and FIR lost against us on 6/6, Your Lordship.
What is your FIR?
Page 30, Lordship. Lost by us, Lordship. May I read, Lordship?
Yes. No, what you have alleged?
Lordship?
What have you alleged? Okay, read.
Lordship, there is POCSO 8, Lordship, but this is totally false and fabricated one, Lordship. Incident, Lordship, kindly page 30, Lordship made it clear, Lordship. এজাহাৰকাৰী বিনীত নিবেদন এই যে যোৱা 29/5/26 তাৰিখে ৰাতি ভাত পানী খাই মোৰ ছোৱালী নাবালিকা ছোৱালী আলমিনা বেগম বয়স অনুমান 16 বছৰে পঢ়ি আছিল ৰাতি অনুমান 11টা বজাত মোৰ ছোৱালীজনী বাহিৰত পেচাব কৰিবলৈ যোৱা মাত্ৰকে 1 নং পদকীয়াজনে হঠাৎ পিছফালৰ পৰা দৌৰি আহি হাতেদি মুখত হুপা মাৰি ধৰি তাইৰ শৰীৰৰ বিভিন্ন ঠাইত বলপূৰ্বকভাৱে স্পৰ্শ কৰে লগে লগে মোৰ ছোৱালীজনী চিঞৰ বাখৰ কৰাত গ্ৰান্ট পিৰিয়াৰেছ বেল এণ্ড ওৱান অফ দেম গ্ৰান্ট ৰেগুলাৰ বেল গ্ৰান্ট পিৰিয়াৰেছ বেল এণ্ড ওৱান অফ দেম গ্ৰান্ট ৰেগুলাৰ বেল Lordship. Now, Lordship, FIR loss against us, Lordship, page number 20, Lordship. They lost it on 6/6 and we lost it on 2/6, Your Lordship. And Lordship, there is another fact, Lordship, kindly page number.
What is the allegation against you?
Allegation, Lordship 61-2-331 74 118 and 198 and POCSO 8, Lordship. Lordship, kindly page number 18, Lordship. Seven number point, Lordship, details of suspected accused person, Lordship. Here, accused number 3 noted as Syed Ali, and in page number 20, Lordship, accused number 3 shown as Azinur Ali, Lordship. And main allegation against, according to this FIR, Lordship, main allegation against accused number 2 and 3. But both the pages 2 and accused number 3 is different, Lordship. One said Syed Ali and another said Azinur Ali. And I am for the Azinur Ali, Abu Zilal and Salamuddin, Lordship. And also, Your Lordship, accused number 7, 8, and 4, 5, and 6 already granted bail, Lordship. Page number Lordship
You are for,
47.
you are for,
I am for Azinur, Abu Zilal, and Salamuddin Lordship. This is totally false and fabricated one, Lordship, as the incident occurred to us, Lordship. We are the victim of this case, Lordship. Kindly allow us to protect us, Lordship. We will appear before the investigation authority. Meantime, CD may be called for, Lordship. There is definitely something fishy, Lordship, as accused number 3, other page shown as another and other page shown as another, Lordship.
nothing fishy.
POCSO is there.
Oxo is there.
Yes. Notice to go, my lord. At this-
Lordship, already, in my FR cases, already granted bail, Lordship. 2 of them anticipatory bail and 1 regular bail, Lordship. BA question, 4, 5, 6.
Yes, Mr. Bashir.
My lord, here, my lord, the prima facie in the, my lord, that is the FIR, my lord, in the vernacular part, page 20, my lord. Very clearly stated, my lord, that প্ৰৱেশ কৰি 2 নং সোপা মাৰি দি ডিঙিত ধৰি ঘৰৰ পৰা বাহিৰত থকা তামোল বাৰী লৈ মোৰ নাবালিকা ছোৱালীজনীক কাপোৰ খুলি দলবদ্ধভাৱে ধৰ্ষণ কৰাৰ চেষ্টা চলায়। মানে POCSO is there, my lord, at this stage, my lord, my humble prayer is, my lord, notice to go, my lord.
Lordship, already, Lordship, my accused, in this FIR, accused number 4, 5, 6 granted bail, Lordship, by the trial court below, Lordship. Kindly page number 34, Lordship.
4, 5, 6.
4, 5, 6. Lordship.
They were arrested,
Yes, Lordship.
Then, my lord, there is a pre-arrest bail.
but this is a pre-arrest bail.
Already,
application.
and 9 also granted bail, Lordship. Pre-arrest bail, Lordship.
And your bail application was rejected.
Yes, Lordship.
Where is the rejection order?
Page number 37.
After
Lordship,
perusal of the CD, my lord, that is, my lord, rejected, my lord.
Lordship, as Lordship, we have lost the FIR first, Lordship. Incident occurred on 29. We have gone to the police station on 30. Medical also done on 29, Lordship. There is also medical report. Page number 21, Lordship.
No, Gorbera. We'll issue notice.
Kindly, Lordship, till then, Lordship.
Notice has to go.
Yes, Lordship, but till then, Lordship. As Lordship, our FIR accused person already granted bail, Lordship,
No,
pre-arrest bail, Lordship.
But
There is also.
your bail application was rejected after perusal of case diary
Yes, my lord.
by the sessions court. So without perusal,
See, as per FIR, Lordship, 3 main allegation against accused number 2 and 3, Lordship. And accused number 3 is shown as Syed Ali, Lordship. I am Azinur, Abu Zilal, and Salamuddin, Lordship.
no,
Kindly-
Syed Ali in the written
In the
form,
form,
written
Lordship,
format,
yes.
which is filled up by
There is
police.
Lordship, that's why this they
No.
made mistake, Lordship.
We are issuing notice.
And Lordship, kindly 7 or 8, Lordship, because there is no direct allegation against 7 or 8, Lordship, of POCSO, Lordship.
Yes. 7 and 8. Who are the petitioners? Abu Jilal and Salamuddin.
Yes, Lordship.
Miss, what is your name?
P. Kolita, Lordship.
P. Kolita, learned counsel for the petitioner. Also, Mr. K. Bashir, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners Azinur Ali, number 1 Azinur Ali, number 2 Abu Jilal alias Abu Jehal, number 3 Salamuddin alias Abdul Salam, who are apprehending their arrest in connection with Nogorbera PS case number 30/2026 under section 61 within bracket 2 /331 within bracket 4 /74 /118 within bracket 2 /189 within bracket 2 of BNS, read with section 89 of POCSO Act 2012. The gist of accusation in this case is that on 6/6/2026, the mother of the victim girl had lodged an affair before the officer in charge of Nogorbera police station, inter alia, alleging that the accused persons named in the affair, 9 numbers of accused persons named in the affair, have tried to have assaulted the minor daughter and other family members of the first informant. It has been categorically alleged in the affair that accused Jainur Ali and Azinur Ali, within bracket petitioner number 1, entered into room of the minor daughter of the informant, and after covering her mouth, she was taken outside, and an attempt to rape was committed on her. It is further alleged in the affair that after the said incident, the altercation occurred between the parties, and the father-in-law of the petitioner, father-in-law of the informant, was seriously beaten up by the accused persons named in the affair. Stop. Learned counsel for the petitioner submits that the allegations leveled in the affair are not true. She submits that, in fact, on 2nd of February, 2nd of June 2026, the wife of the accused number 1 named of the wife of the Abdul Hussein had lodged an affair against one Amjad Ali, Habez Ali and Salam Ali of trying to outrage the modesty of the minor daughter of the first informant. And in the said incident, whose finger was severed?
That the mother of the that minor daughter, Lordship.
The
Accused number 9, Lordship. Joytun Nessa.
one finger of the mother of the victim girl, Joytun Nessa, also was severed. Learned counsel for the petitioner further submits that though this case has been registered inter alia under section 8 of the POCSO Act also, however, no allegation under POCSO Act has been made against the petitioners number 2 Abu Jilal and Salamuddin, and therefore there may not be any bar in granting any interim protection to them. On the other hand, learned additional public prosecutor submits that since the offense involved in this case, one of the offense involved in this case is under section 8 of the POCSO Act, notice shall have to go to the respondent number 2. And case diary may be called for. Stop. Let the case diary be called for. When is the date of their case?
23/7.
Let the case be listed on 23/7/2026 for case diary. In the meanwhile, since the accusation under POCSO Act is only against Azinur Ali, that is petitioner number 1, and as against petitioner number 2 and 3, no such allegation is there. Hence, and since out of 9 accused named in the FIR, how many are on bail?
4, Lordship. 3 of them regular bail, 1 is
Four accused persons are already granted bail by which court?
trial court below, Lordship.
In the Court of London, Special Judge Kamrup Amingaon. Hence, the petitioner number 2 and 3 are directed to appear before the investigating officer of Nongarbera PS case number 30/2026 and cooperate in the investigation. Stop. If they do so within the stipulated period of time, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of the arresting authority. List on 23/7 for case diary.
Obliged, Lordship.
Item 37. In this case, both the petitioners are brothers, lordship, they are government employees, lordship. One is a school teacher and my lord, 2 is a grade 4 of high school, lordship. Now, fact of the case, lordship, as regards the land dispute, title suit is going on between 2 parties, 2 families, lordship. As regards position, lordship, there was a quarrel between the plaintiffs and the defendants, my lord, families, lordship. We are not part of those families, lordship. We are outsider, lordship. Now, quarrel was there, my lord, injuries from both sides, people were there, lordship. Unfortunately, my lord, one person, my lord, plaintiff number 1, my lord, got injured, my lord, injuries lordship, he was taken to AIMS lordship. In AIMS, he was medically treated, my lord, and on the same date, my lord, after my lord, finding him okay, lordship, he was released, my lord. Thereafter, on the way, my lord, his health condition was stated to have been, my lord, had been, my lord, deteriorated, lordship. Then he expired, my lord. Now, kindly see the FIR is at page 19, lordship. My lord, FIR from the both sides were lost, lordship. In the cross FIR, my lord, this charge sheet has been submitted, lordship. Now, kindly see at page 19.
Charge case.
My lord, in other case, lordship, plaintiff's case, charge sheet has been submitted, lordship. In defendant's case, my lord, we are for bail in the defendant's case, lordship. Now, at page 19, lordship, kindly see, lordship. First of all, lordship, my lord, married, lordship. With due respect, I beg to state that on, lordship got it.
What is her name?
My lord,
Who are the petitioners?
now, lordship,
Sahali and Rustam Ali.
page 20, lordship, list of accused, lordship, 14 accused persons, lordship, except the petitioners, my lord, all 12 are on bail, lordship. My lord, accused numbers, lordship, 4 and 6 were arrested, lordship. They have been released on bail as per the order of this honorable court, lordship. And others have been granted interim bail by this honorable court, lordship. Because of, my lord, the charge sheet in the cross case, my lord, Dolgaon PS case number 47 has been submitted against all 10, my lord, accused persons in that case, lordship. That is why, my lord, interim bail was granted, my lord, accused number 3. My lord, because the charge sheet was submitted, interim bail was. That petition is also pending, lordship. Now, thereafter, my lord, the other 6 accused persons, accused number 1, Amez Ali, lordship. He also approached this honorable court, my lord. His bail petition was allowed, my lord. Absolute bail was granted, lordship. Other 5 accused, lordship. This honorable court, my lord, granted absolute bail, lordship. My lord, considering the stage of investigation, my lord, progress of investigation, PP submitted, learned PP submitted, the investigation is progress. This honorable court, my lord, granted bail, absolute bail. Thereafter, my lord, kindly another 3 petitioners, accused, lordship, accused number lordship 5, 7, and 8, lordship. They approached this honorable court, my lord. This honorable court also granted interim bail, lordship.
Sahali and Rustam Ali. You
Now,
are
Sahali and Rustam Ali, lordship.
Rustam Ali
I'm
is
sorry,
accused
lordship.
number.
Not 8, lordship, 9. Sahali, Rustam Ali are now before this honorable court, lordship. Now, the cross affair, kindly see at page 40, lordship.
Be slow, but
I'm sorry,
be
lordship.
accurate.
I'm sorry, lordship.
Because if you make wrong statement,
I'm in hurry,
you will
lordship.
lose credibility.
Sorry, lordship. Kindly see page 40, lordship.
Yes.
This is the cross case, lordship. It was lost on, my lord, 10/3/2026 as the injured year, my lord, in hospital, lordship. Married, lordship. With the respect, I beg to state that on 5/3/2026 at about around 12:30 a.m., the below mentioned accused persons armed with daws, daggers, sticks, sharp objects, etc., collectively entered our.
Case diary would be required.
Yes, ma'am.
Case diary would be required.
Now, other orders, lordship, in other cases, lordship, kindly see at page, all orders of this honorable court have been annexed, lordship.
No,
Lordship.
others are granted bail after perusal of
the case. Now, interim bail is also there, lordship. My lord, accused number 3, kindly, lordship, kindly see at page 47, lordship. He is a Taqdir Ali, lordship. My lord, page number 48, kindly see relevant, lordship. This is for second paragraph. Married, lordship. Learned counsel for the petitioner has submitted that a cross FIR in respect of the same incident was registered as Dalgaon PS case number 47 of 2026, in which a charge sheet has recently been submitted, the fact that a charge sheet has been laid in the Dolgao PS case number 47 of 2026 has also been confirmed by the learned APP. The learned APP, however, submits that the case diary was called for in connection with the Dolgao PS case number 41 of 2026 yet to be received. In the facts and circumstances of the case, this court deems it fit to direct the petitioner to appear before the investigating officer within a period of 10 days from today and cooperate with the investigation.
What happened on 19/6?
Bottom lordship. Now he has appeared lordship. Thus petition is pending lordship. He is cooperating with the investigation lordship. Now other accused persons lordship, interim bail application lordship, that is at place 13 lordship. 62. Annex 13. Accused number 5, 7, and 9. He is Muhammad Ali, Shafiqul Islam, Meser Ali. My lord, in this case, my lord, from paragraph 5, kindly see lordship. May I read lordship? At page 63. In the FIR pertaining to Dolgao PS case number 41, 2026, wherein the petitioners are seeking bail in present petition, 14 accused persons have been named. It is submitted that so far accused number 1, 10 to 14 have been granted bail by this court. The present petitioners are accused numbers 5, 7, and 9. Call for the up-to-date case diary to ascertain the status of the investigation and to verify whether the same has been completed, like in the Cross case. However, in the interim, it is provided that in the event of arrest, the petitioners named above shall be released on interim bail, pre-arrest bail, in connection with the above noted case on furnishing bail bond of rupees 30,000 each with one surety of like amount each to the satisfaction of the arresting authority, subject to the following conditions. Lord. Now, only, my lord, the petitioners, my lord, before you lordship, and others are, my lord, on bail lordship. Some are on interim bail lordship, and 6 numbers accused, including accused number 1, is, my lord, on absolute bail lordship. So they have been, my lord, cooperating lordship. We will also cooperate, lord, school teachers and government employee laws.
Yes.
Yes, my lord, today it is a motion day, and it is today for the first time this my lord petitioner approached before your lordship, my lord. Now, my lord, that is, my lord, my learned senior colleague, my lord, relying, my lord, 2 orders, my lord, whereby, my lord, interim protection granted, my lord. In, my lord, page 62, that is, my lord, AB 1518/2026, my lord. There in, my lord, page 63, my lord. Page 63, para 4, my lord. Para 4, only, my lord, relevant part, my lord. That is, my lord, reflect. Mr. Ahmed Learned Counsel submits the FIR relating to registration of Dolgao PS case number so-and-so in the same investigation is completed, resulting in submission of a charge sheet, and that the same is reflected in the order dated 2/6/2026 passed by the coordinate bench in AB number 875/2026. Now, my lord, kindly peruse, my lord, 875/2026 order, that is in page 47, my lord, whereby interim is granted, my lord.
Yes. That is accused number 3.
Yes, my lord. 875. First, my lord, this, my lord, on the basis of this 875/2026 order, my lord, next, my lord, interim is granted, my lord, clearly reflected.
Yeah.
Now, my lord, page 48. Lordship may kindly peruse page 48, my lord, 875 order.
Yes.
My lord, the learned APP, however, submits that the case diary was called for in connection with Dolgao PS case number is yet to be received, my lord. That was, my lord, the situation at that point of time, because, my lord, CD was called for, my lord, and that was not, my lord, placed before your lordship. Now, my lord, this is a, my lord, case of, my lord, murder, my lord, where, my lord, in the, my lord, vernacular part, my lord, of the FIR, my lord, page 28, my lord, all are FIR name, my lord, Odokia Gonor, মোৰ পিতৃক প্ৰচুৰ মাৰপিট কৰাত গুৰুতৰভাৱে জখমগ্ৰস্ত হৈ মৃত্যুবৰণ কৰে. Very clearly stated, my lord. Only my prayer, my lord.
When is the
Order submitting lord.
when is the case diary?
My lord, case diary, my lord, I don't know, learned PP can say lordship. Now,
When in the connected cases.
my lord, in the other case, lordship, in the it is, my lord, 3/8/2026 lordship.
3/8.
2026 lordship. It is fixed on, my lord.
Or death may be.
At first 64, kindly see lordship. My lord, initially, my lord, in case of my lord, case number 3, my lord, CD was not called, interim was not granted by, because my lord, charge sheet was submitted lordship and CD was not there, my lord. That is why my lord, the interim was granted lordship. My lord, as my lord, the honorable court, my lord, I submitted before the honorable court lordship. My lord, that prima facie case has been established in the case lordship. There was sudden
That
provocation.
does not mean that this
Lordship,
case
yes,
is false.
I am before his lordship. Now at
Are the MH.
64, my lord, date is fixed. as
We are calling case diary
My lord.
without any
Oh,
protection.
my lord, we are government employees lordship.
We are-
Others are granted
We
lordship.
are fixing
My
short
lord,
date.
out of 14, my lord, 12 have been are in my lord on bail lordship. So we are on what two petitioners, two accused lordship. My lord, we'll also cooperate with the investigation lordship. We are.
Heard Mr. M.H. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Bashaw, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Saha Ali and Rustam Mandal, who are apprehending their arrest in connection with Dolgaon PS case number 41/2026 under section 103 within bracket 1, 118 within bracket 2, 190 within bracket /191 within bracket 2 /324 within bracket 4, 329 within bracket 3 of BNS 2023. The gist of accusation in this case is that on Seven 3/2026, one Mafizuddin had lodged an FIR before the officer in charge of Dolgaon police station, inter alia alleging that on 5/3/2026 at about 12:30 a.m. the 14 numbers of accused persons named in the FIR trespassed into the land of the first informant and uprooted the plantation there. And when they were resisted, they started beating the father of the petitioner, father of the informant, wife of the informant, brother of the informant, as well as nephew of the informant, causing serious injuries on their persons. It is also alleged therein that though the father of the informant was taken to hospital, however, he succumbed to his injuries. Learned counsel for the petitioner submits that the allegations leveled in the FIR against the present petitioners are not true, and in connection with the same incident, another FIR was lodged against the informant against Mafizuddin and others, and 9 others.
Lordship.
Stop. He submits that on the basis of the cross FIR, which was lodged, Dolgaon cross FIR, Dolgaon PS case number 47/2026 was registered, and in the said case, charge sheet has been laid against all the accused persons. He further submits that out of 14 accused persons named in the present case, including the present petitioners, how many have been granted bail?
My lord, 2 have been, my lord, regular bail, my lord, and 10 have been, my lord, pre-arrest bail, my lord, including, my lord, interim bail, my lord. My lord, 4 persons have been granted interim bail, lord. And 6 have been absolute bail, lord.
Two accused persons have been granted regular bail, and other 10 are on either anticipatory bail or interim anticipatory bail. He submits that only the present petitioners are without any protection. He further submits that since 12 out of 14 accused named in the affair are on some kind of protection, the present petitioners may also be granted protection by this court. And he submits that they will cooperate in the investigation. He also submits that while granting interim bail to one of the co-accused in AB case number 875/2026, a coordinate bench of this court took into consideration the fact that in the cross case filed by the present petitioner, charge sheet has been laid against all the accused persons. So, on the other hand, an additional public prosecutor has prayed for calling of the case diary and has opposed grant of any interim protection to the petitioners at this stage, considering the nature of allegations, nature of offense involved in this case. Let the case diary be called for. Let this matter be listed on 4th. When is the date?
In other case, 3/8, that is fixed on, my lord,
Let
3/8.
the matter be listed again on 3/8/2026, along with AB case number 1518/2026. However, as in the meanwhile, as 12 of the named accused are already on some kind of protection in this case, and from the affair, it does not appear that the present petitioner stand on any different footing from that of those accused persons who are already on bail. Hence, both the petitioners are directed to appear before the investigating officer of Dalgaon PS case number 41/2026 within 7 days from the date of this order and cooperating in the investigation. So, in the event, if they do so, continue. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on interim bail of 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority. List on 3/8/2026 for
Cost of life loss.
case date.
Made, please, your lordship. The FIR is at page 11, your lordship. The 11 page is page 13, your lordship. In this case, your lordship, the informant's nephew, while he went to take a bath in the river, he died.
Okay.
And then, your lordship, they are alleging that the Sen Mahal is digging pits due to which this incident has occurred. I am the manager of that Sen Mahal, your lordship. And that is why I am apprehending arrest. My previous bail application was rejected in the sessions court, your lordship.
After perusal of the case diary,
After perusal of the case diary.
then we'll have to call for the case diary without any protection.
But I'm only praying for some protection, if your lordship may kindly grant, because I am not at all responsible for that particular digging of the pits in the river, your lordship. I'm just the manager.
What do you do? Manager has to manage. You are responsible for it.
Yes, your lordship. But the digging part, the allegations that they've made, your lordship, if your lordship may kindly see it. I'm not involved in the digging. I'm just managing the affairs of the Mahal, your lordship. Only some protection at this stage, your lordship, if your lordship may kindly.
Yes, Mr.
Why rejecting, my lord? It is that on perusal of the materials, the case diary, it appears that there are prima facie ingredients of section 105 PNS against the accused person. The negligent act of the accused has resulted into creation of the broad river bed, which caused the death of 8 to 10 years of the minor. And, it is also stated the initial stage while rejecting, that was the minor.
How he died?
My lord, it is in my lord page 21.
Page 21, your lord.
Page 21 of the my lord petition.
Para 6, your lord.
Para 7.
6 or 7.
Heard Mr. T. Deori, learned counsel for the petitioner. Also heard Mr. K. Bashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Kungursa Busumatari, who is apprehending his arrest in connection with Paneri Police Station case number 5/2026 under section 105/61 within bracket 2 within bracket small a of BNS 2023. The gist of accusation in this case is that on 7/6/2026, one Shri Swapan Chandra Das has lodged an FIR before the officer in charge of Paneri Police Station, interiorly alleging that on that day at about 1 p.m., when his nephew Gordas went to take a bath in river Nanoi, he accidentally fell into illegally excavated ditch. So, it is alleged that said ditch was dug by who has dug that ditch?
There are excavation work going on, Your Lordship.
Who is doing the excavation? Who is responsible for excavation?
There are allegations that there are.
You are manager of which company?
I am the manager, Your Lordship, may kindly produce the page 18, Your Lordship. I am the collector cum manager of Nunoy Sen Stone Mahal. The Stone Mahal has been given to a lessee, Your Lordship. The lessee has appointed me as a manager.
He declared lastly. Dug by crusher mills illegally carrying out excavation in the said river, and similar incident occurred earlier also. Learned counsel for the petitioner has submitted that the petitioner is the collector and collector cum manager of Nunoy S/S Mahal number 1 Githibari, and he is not in any manner responsible for the death of the nephew of the first informant in the instant case. He submits that the petitioner is not directly involved in the circumstances which resulted into death of the nephew of the first informant. He submits that he is ready to cooperate in the investigation and his custodial detention may not be necessary for fair completion of the investigation. On the other hand, learned additional public prosecutor submits Mr. K. Bushaw, learned additional public prosecutor submits that the prayer for bail of the present petitioner was rejected by the Court of Learned Additional Session Judge after perusal of the case diary, and while rejecting the petition, the said court made an observation that materials are insufficient to justify grant of pre-arrest bail to the present petitioner. He also submits that the case diary may be perused before granting any relief to the petitioner at this stage. Call for the case diary. let this matter be listed again on when can you bring?
Shortest, madam.
17th,
Paneri Udalguri,
17th.
17.
Till then, no relief.
I'm bring it to you.
My please, your lordship. Lordship, the allegation in the FIR is basically stealing of a vehicle. And the vehicle which has been stolen already recovered by the police, and the person who has stolen the vehicle, he has been already apprehended by the police. And the police is on search on me because of the confession as alleged by the him that and the confession recorded by the other co-accused person that I was also involved. In that duration, police is on search. So nothing, my involvement is no way connected. I'm not a named affair person.
What he has
My
confessed?
lord, at page 8, my lord,
What has been confessed?
or that is at page 15, that in the ground of arrest, my lord. Ground of arrest, serial number 3.
What is your name, Ashish?
Yes, Asisuddin Ahmed.
You are the mastermind.
As they have stated, my lord. So I have no connection with that alleged offense, my lord. I'm no way involved. If your lordship will look at the FIR at page 8, my lord.
Yes, miss.
That was
Vehicle
my
has
lord.
been recovered.
My lord. That was my lord. That part is my lord already my learned friend, my lord. That my lord his involvement in this part. And in those cases, my lord, probability is always there, my lord. Because my lord, he took the my lord car, my lord, then GPS was my lord.
No, he
Heard-
didn't. Yes.
Heard Mr. B.M. Deka, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Asis Uddin Ahmed, who is apprehending his arrest in connection with Hatigao PS case number 65/2026 under section 318 within bracket 4/303 within bracket 2 of BNS. Stop next para. The gist of accusation in this case is that on 5/4/2026, on 4/4/2026, one Ashiruddin Ali had lodged an FIR before the officer in charge of Hatigao police station that his Hyundai Venue motor vehicle bearing registration number AS01GM9430 was taken by his friend Ariful Islam, and thereafter same was not returned back. And when the first informant confronted him, it was informed that the vehicle was handed over to some other person for on self-drive basis. Learned counsel for the petitioner submits that the present petitioner is in no way involved in the offense alleged in this case, and he has not been specifically named in the FIR. He further submits that however, in the forwarding report of a co-accused, namely Fardeen Ahmed, the investigating officer has mentioned that during investigation, one of the co-accused revealed the name of present petitioner as the mastermind of the offense involved in this case, which he submits is not true. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in investigation, and in the meanwhile, the missing vehicle has already been recovered. Stop. Let the case diary be called for. Let this case be listed again on 5th of August 2026. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, he, as discussed in the foregoing paragraphs, the above named petitioner is directed to appear before the investigating officer of Hatigao PS case number 65/2026 under section 318 within 2026 stop within a 2026 within a period of 7 days from the date of this order. Stop. If he does so within the stipulated period of time, in the event of his arrest, he shall be allowed to go on interim bail of rupees 40,000 with one security of like amount, subject to the satisfaction of the arresting authority. List accordingly for yourself.
Much obliged, Mandu. May please, Your Lordship, that impugn order is at page 34, my lord, that during the course of execution proceeding, my lord, judgment debtor file a application for ascertaining the exact, my lord, identity, file an application for praying for Amin commission, and that was rejected. Only count that, my lord, because the case is a origin decree was the compromise decree. After compromise decree, they have purchased separate plot of land, my lord, by registered sale deed, my lord. Compromise decree was in 90 and 96. They have purchased separate plot of land, my lord, by separate deed and mutated, and that's why wait for to just to identify. Your Lordship may kindly impugn order is a page 34. Page 34. Page 134. Annexure 11, page 134. Let's see. Parties represented in the petition so and so filed by the decree holder, praying for another date for adjournment. It is stated that petitioner is without.
No, why Amin commissioner is required?
Because yes,
the writ will
but it will itself
describe the plot of land. The number, pata number will be
Your
mentioned.
Lordship may come to the page, my lord, objection raised, my lord, page 45, page 45, my lord. Page 31 is the execution petition, my lord, and page 40 starts from page 45, objection of execution, my lord. Page 45, para 9, my lord, that is Khitish Chandra Saha purchased a plot of Schedule A mansion land from Shahjahan Ali, filed registered sale deed number 2272 on 6/11/96. And my lord, the description of the said land is given Schedule A of the written statement. That is Jawaharlal.
No, your prayer was dismissed by the decretal court, by the executing court, by stating that decree will be executed as per the description mentioned in the.
Yes, my lord.
decree.
Yes, because the description, if the description is
If
only
it is,
thing is
if
that,
it is unidentifiable land, then it will not be executed.
my lord, that's why, my lord, that if there is overlap, my lord, because my lord, the specific
specific statement is there, my lord, that we have person that origin that the judgment origin, my lord, that decree is a, my lord, compromise decree. As because it's a compromise decree, I would not have come. Because it was purchased, my lord, separately.
No, what is the
But
case?
my petition, it is clear, my lord, in my petition, my lord, in page, my petition is page, my lord.
No, the executing court has in the impugn order itself mentioned that the delivery of possession shall be strictly in accordance with the description contained in the decree. Where is the difficulty? You tell me where is the difficulty?
Because, my lord, that, my lord, when I filed the petition, my lord, from page 51, my lord, 51 schedule A land, which is purchased by bill, my lord. Page 51, kindly, your lordship may come.
No, what you want to say? Yes.
Page 51, my lord, and the petition we filed for, my lord, appointment of commissioner.
Okay.
That here is, my lord, in para 3,
Yes.
at page 52.
Yes.
Then that thereafter judgment date or number 1 Liton Saha, number 2 4 Subal Saha filed their written objection against the aforesaid application stating that let Kiti Chandra Saha purchase Schedule A mention land from the Shahjahan and Sohar Ali Bhai register sale 2272 dated 6/11/96. This is Schedule A land, and Schedule B land, my lord, is purchased by Zohar Ali. Next page, my lord, page 53. The Schedule B land. Their Schedule B land. Their objection is, well, Schedule A and B, which is purchased by bill, and Schedule O1 and Co3, which is a decree land. They are saying, well, it is same land. And I am saying that it is a contiguous land, not the same land, my lord, which may overlap, but that's why proper identity is necessary. That much may be done even at the time of execution.
No, but the executing court also said that execute the decree only after identification.
Yes, sir.
That has been stated in the impugn order. Read last para of the impugn.
Yes, ma'am. That last para impugn order only in the decretal land. But a decretal land is, my lord, decretal land is of 90. Decretal land is of, my lord, decree is your lordship, my lord. I have given the decree because Annexer 1, my lord, Annexer 1 is the petition for decree, and decree is of, my lord, 90.
So,
my lord, thereafter, my lord, that is subsequent says, my lord, that they have purchased the land contiguous to that decretal land.
who they means?
They means, my lord, judgment debtor, LR of judgment debtor, they have purchased. That when I file this objection, my lord, when I filed this objection, I have clearly stated, my lord, that the judgment LR of judgment debtor has purchased the
Whether executing court has issued writ.
executing court had issued writ, my lord.
When is the next date? Heard Mr. P. Goswami, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 27/3/2026, passed in title execution case number 14/2013 by the Court of London Civil Judge Junior Division Darong Mongolday, whereby the application filed by the present petitioners under Order 26 Rule 9 read with section 47 of the Code of Civil Procedure 1908 for issuance of Amin Commissioner for proper identification of the decretal land was rejected by the by the executing court. Learned counsel for the petitioners has submitted that you are the judgment debtor, that the decree sought to be executed in the aforementioned execution case is a compromise decree which was obtained in title suit number 15/1986, and after passing of the decree, the present petitioners have purchased two separate plots. Two separate plots.
Two plots, separate plots.
Two
My lord.
separate plots.
One of the defendant number 2 and only the defendant number 1, my lord. The petition is defendant number 1, 2, and 1, 3. They are LR.
Separate plots of land, which is contiguous to the decretal land, and unless the decretal land is properly identified before executing the decree, it would cause great prejudice to the present petitioners. Issue notice to the respondents. How many decree holders are there?
My lord, decree holders, my lord. Two only, my lord. Legal representative 1 and 2, my lord. Only one was the plaintiff, my lord. Their sons and daughters, 2 decree holders.
Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon all respondents by speed post as well as by usual mode, returnable on 5th of August 2025, as well as by usual mode. Stop. In the meanwhile, considering the averments made in this revision petition as well as submissions made by learned counsel for the petitioner, the further proceeding of title exhibition case number 14/2013 shall remain stayed till next returnable date. List accordingly.
May please, your lordship. Here, my lord, I am partially aggrieved by an order passed by the learned CGM Kamrup, my lord. The gist of the case is that, my lord, the police has raided my residence, and after the raid, my lord, some areca nuts has been seized from my residence. Thereafter, a police case has been registered.
Where is the impugn order?
Impugn order is at page number, my lord, 64. During the charge frame, my lord, I was discharged, but the areca nuts which are seized from my possessions, my lord, those are directed to be destroyed, my lord, within 30 days.
Whether same has been destroyed or not?
No, it's not destroyed yet, my lord.
So far my information is concerned, because it was directed to destroy it after 30 days, my lord. I am aggrieved by the portions, my lord, which is at page number 68, my lord. From the second paragraph, from the top, my lord, 68. May I read, my lord?
No. No. Heard. Mr. What is
So
your,
I have a few lines, Lordship.
you take instructions?
Lordship, I have to take.
My lord.
Lord.
Only one prayer, my lord, till the instructions, this arcanum may not be destroyed, my lord. The direction may be,
Yes.
if it is destroyed, then my lord.
Heard Mr. M.A.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 438 of BNSS has been filed by the petitioner Akram Ali, impugning the order dated 17/6/2026
I'm partially impugning, my lord, because by the order, I was also
passed by the Court of Learned Chief Judicial Magistrate Kamrup Petro in PRC case number 22/2026, whereby the areca nuts seized from the possession of the present petitioner was directed to be destroyed within 30 days. Stop. It is submitted by learned counsel for the petitioner that the petitioner is aggrieved by the impugned order only to the extent of its directing this destroying of areca nuts within 30 days, and he is not aggrieved with the remaining part by which he was discharged of the offense alleged in PRC case number 22/2026. How many petitioners were there?
Only one petition,
No, how many accused were there
only one,
in that PRC?
the petition only. The case was registered against the petitioner.
However, in these things, Lordship, he has indirectly, he tried to get a Jimma of these things, Lordship. But the thing is that, Lordship, as it is clearly stated in the order, Lordship, 17/6/2026, that he is not the owner. It has not been found out from the records. However, if I look into the order, Lordship, Jimma here also given the bail, Lordship, in that page 43, it is clearly stated that, may I read a few lines, Lordship. He get bail so that he may produce all necessary documents before the investigating authority to prove the manner in which suspected battles have come into his possession. That order was in, Lordship, 9/12/2025. And this impugned order is, Lordship, 17/6/2026. And in the order, it is clearly reflected, Lordship, there is no record in the case to trace out the owner or the custodian of the stolen property to establish its trial from the owner or custodian. He is not the owner, Lordship.
Yes.
The areca source is from my custody. I was discharged
But
from.
it was not, he has given full time, Lordship, during the investigation period.
don't
to
know.
produce the document.
We'll
Whatever,
call-
Lordship,
Let the records of
Lordship.
PRC case number 22/2026. No, let the scan copy of the records of PRC case number 22/2026 be called for from the trial court. The registry to take steps for requisitioning the records. Let this case be listed again on 6th of August 20.
6th of August.
See.
So that may be given, my lord. Because it's from Kamrup, my lord. I mean, it's from Kamrup. I mean,
23rd of 24th July. 24th July.
Only
Stop.
scan copy called for, Lordship.
Only scan copy.
Lordship.
However, considering the submission, considering the averments made in the instant revision petition till next returnable date, the operation of impugn order dated 17/6/2026 passed in PRC case number 22/2026 to the extent it's directing the destroying of areca nuts shall remain stayed.
So, but my lord, the report is concerned because it was directed to destroy us because the articles are not in for human consumption. That is the only ground for directing to destroy the areca nuts, my lord.
No, no,
That is
not,
not,
that is not the only ground.
in the impugn order, my lord.
No,
Isn't
that
it
is
your-
not the only ground, Lordship, because here, there is no one to get
I am
the.
referring the impugn order, my lord.
Okay, let the record come.
Record is over.
May I please, your lordship? My lord, this is a matter, my lord. We are basically apprehending an eviction drive, my lord. Lord, what has happened?
On what basis?
My lord, the basis is that, my lord, already there is an order passed by this honorable court, my lord. And there is a direction, my lord, that there on the basis of an hearing to be conducted, my lord, and speaking order is required to be passed. Now, my lord, while pendency of that, my lord, now the authorities are pressurizing us, though, my lord, admittedly, no any speaking order, no any order had been issued till date. Even, my lord, after filing of this writ petition, the last night, my lord, the officials has threatened the petitioner to evacuate or the coercive action will be taken. That statement I could not make because, my lord, in that I have already filed the petition, my lord. That is the instruction today I have received, my lord. Now, my lord, basically in this petition, my lord, we are praying that, my lord, a process had been initiated, my lord, long back. My lord, I am troubling my lordships within one annexure, my lord. The, my lord, application which we have made, my lord, in the year, my lord, at page 69, my lord.
No, we'll issue notice.
My lord, yes, my lord, I am also not praying for the, my lord, exactly stay, but my lord, the status quo, my lord, is required to be maintained because, my lord, if my learned friend assures, my lord, my submission is that, my lord, I know, my lord, there is a pressure on the, on the part of my learned friend
There is
also.
already
my lord.
adjudication is done. Kindly come to page.
No, adjudication has not been done, my lord.
This order, speaking order, we are in the process of giving the speaking order. Lord.
Till the speaking order is passed, my
No,
lord, the
Lordship,
status quo may
already-
be maintained, my lord.
Lordship, page 92 already adjudicated, Lord.
No, this prayer has not been adjudicated, my lord. The earlier prayer.
Yes,
No. The earlier prayer, no. The earlier writ petition is also with us, my lord. My lord can compare both the writ petition, my lord. The earlier prayer which we have, my lord, may kindly peruse the.
Maintainability of
My
the
lord,
petition.
yes,
Lordship.
exactly, my lord. My maintainability we can satisfy, my lord, because I have taken care of both the prayers, my lord. In the earlier writ petition, my lord, may be pleased to find my prayer starts from page number 35, my lord. Basically, we are praying that, my lord, the exercise which the state respondent had initiated, my lord, for the purpose of regularization or the, my lord, allotment of the land as per the land policy, that should be culminated to its a logical conclusion. My lord. Either they can grant or they can reject also, my lord. But that exercise till date is still pending, my lord, that no finality has been attained. So, my lord, therefore, we are praying for a mandamus that you complete the exercise, and till the exercise is completed, my lord, we should not be disturbed, my lord. And in the earlier round of litigation, my lord, we have challenged the eviction notices, my lord. That is, we have prayed for certiorari of the
This
eviction.
time
my
there
lord.
is no eviction notice.
My lord.
Neither there is any apprehension
Yes,
that
my
you
lord.
will be.
We have the full apprehension, my lord. Nowadays, my lord.
I found nothing in the writ petition.
No, my lord. What has happened, my lord? Basically, when we file this writ petition, my lord, till the returnable date, my lord, if status quo is maintained, my lord, no prejudice will be caused, my lord. They can take any decision, my lord. On the speaking order also, my lord.
Already that order has already been on
No, status quo has not been passed, my lord. My lord may kindly peruse the last order, my lord, which this honorable court was pleased to
Which
pass.
order? Which order you are?
Page 92 and 103.
Two orders, they have annexed, Lordship.
No, it is starts from page 112, my lord. Paragraph 19. Last night, মানে petition file করার পিছত
No,
আছে ঘটনা আছে।
no, his grievance is
My lord,
his prayer for allotment of land
Lordship.
has not been considered as per the land
And as such,
policy.
my lord, that is the
No,
main
no.
That
grievance.
is the grievance.
yeah,
My lord,
So we issue notice, you take instruction.
my lord, my lord.
Lordship, otherwise, Lordship, on the similar ground, Lordship, a coordinate bench has passed an order recently, Lordship. Now, in that line, Lordship, that may be, this petition may be disposed of, Lordship. Recently passed, Lordship.
কোনটো order? আছে নেকি কপি আছে?
Similar situation, Lordship.
What is your submission regarding his main grievance?
But it,
Yeah.
earlier petition, they have filed, perhaps they have challenging the
Eviction.
eviction notices. Lordship.
No,
It
this
is-
time there is no challenge to any
Yeah.
eviction notice.
Lordship, there,
He's only-
there came before this court on apprehension, Lordship. As the coordinate bench also order passed, Lordship, on the basis of apprehension, they have approached this petition, Lordship, read court, Lordship. Since there is an order, Lordship, not to take course of action, that, or that interim order is still operating, Lordship.
Where is that order not to take coercive action?
My lord, it page 113,
Yeah.
paragraph, clause 8. It is observed that till the aforesaid exercise is
Yeah.
being carried out, no steps be taken for eviction of the petitioners. That is correct, my lord.
So you are already under protection.
Already, that is correct, my lord. That's why, my lord, I have not suppressed anything before my lord, my lord. Now, what has happened, the subsequent events, my lord, after this, we have made this representation, my lord, it starts at page 114, stating that all in details. Now, my lord, this exercise has been carried out by way of an hearing. My lord, may kindly peruse the page number 124, my lord. This is regarding a public hearing in connection to the Honorable High Court's order dated 17/2/2026, and it was fixed on, my lord. This hearing was fixed on 16/3/2026 from 11 AM onwards. Now, my lord, till date, after the hearing, no speaking order has yet been passed. Basically, my lord, they are required to pass an speaking order, then only they can take any coercive action. Now, my lord, when we file this petition, my lord, after this, my lord, for the purpose of regularization, the exercise which they have taken, my lord, for the purpose of allotment of the land, long back in the year 2013, that has not been logically culminated yet. We are not challenging any speaking order yet, my lord. Now, our main prayer is that, my lord, the mandamus should be issued directing the authorities, my lord, to take a, my lord, logical conclusion. Either they can allot us or can reject us also, my lord. That is within their domain, my lord. Within their domain. Now, my lord, till this exercise is completed.
You take instruction
My
and
lord.
file
Yes, my lord.
affidavit in opposition.
Yes, my lord.
But already still there is an interim order. No,
He's not praying
My
for
lord, I
it.
don't know why my learned friend is, my lord, opposing the interim order. I am not saying that we should be, my lord,
evicted or the against the, we are only saying that the status quo till a decision is taken.
That is also
My
not
lord.
required. You are already under.
No, my lord, that is that they are saying that we should not be evicted, my lord. Now, whether the speaking order is passed or not passed, my lord, that instruction is also not available with me. Even my learned friend is also not available with that instruction, my lord.
Right.
That is
My
what
lord.
we have, Lordship. This is under
My lord,
consideration,
my lord.
Lordship. Within a short time, they will pass this order.
Heard Mr. A.R. Mia. Senior counsel assisted by
S.
Ms.
Laskar, my lord.
S. Laskar, learned counsel for the petitioner. Also, yes, your name.
I'm first the
Yeah.
Study Council Revenue Department.
Mr. S. Laskar, standing counsel, revenue department.
1 and 2, Lordship.
Waiting for respondent number 1 and 2, as well as Mr. Yes.
I am for 1, 3, 4,
And 2.
What is your name? We forgot the name.
SS Roy for 1,
Sorry.
4, 5, and 6.
SS Roy, appearing for respondent number 1,
1, 3,
1,
5,
3,
and 6.
4, 5, and 6. This writ petition under Article 226 of the Constitution of India has been filed by the petitioners, namely Hanan Ali and 17 others, praying for a direction for issuance of writ in the nature of mandamus and any other appropriate writ or against the respondent authorities to compel them to consider. You have filed representation.
Yes, yes, my lord, on, is at
Consider
page
this.
78, my lord.
Representation filed by the petitioners for
Page
regularization
69, my lord.
/ allotment of land.
Lands.
You are possessing that land.
Yes, my lord, the land which we are possessing has been stated in details in paragraph 5 at page
Over
11.
which they
My lord.
have the possession in terms of which policy?
My lord, under the Assam Land Policy 2019, my lord,
Assam
that
Land-
policy is available, my lord.
Land Policy
My lord.
2019. Learned counsel for the petitioner submits that prior to approaching this court,
My lord.
the petitioner had earlier approached this court by filing another writ petition, that is writ WPC number 818/2026, whereby they have impugned the eviction notice.
Eviction notices, which is, my lord, may be pleased to find, we have also annexed, my lord. those
And the
notices.
said
My-
writ petition was disposed of by a coordinate bench of this court by its order dated
my lord.
Nin-
Order dated
19,
19/2, my lord.
19
19 to 2026.
2026.
2026, wherein amongst other directions, a direction was given to the
Order
respondent
date.
authority
I need to put that.
that before the exercise of deciding the representations filed by the petitioners is complete, no steps be taken for eviction of the petitioners. Stuff. Learned standing counsel, revenue department, as well as learned government counsel appearing for respondent number. Mr. Roy, you are appearing for?
State Council.
Appearing for the state.
Yes,
Yes.
All respondents are represented.
Yes.
my lord.
Submitted that. the respondent's authority have already completed the process
Okay.
of hearing and would be passing the speaking order
Goodness of the
very soon.
Lordship.
And as such, they pray for some time to file, for some time for taking necessary instructions in this regard and for filing affidavit in opposition. The prayer is allowed. Let this matter be listed again on when
Last part.
or we
Mal.
or a date is required.
Lordship, convenience, Lordship, after that.
August 4th of August.
Mal.
4th of August.
Till then, the status quo as
You
on
are
date.
already under
Okay.
protection.
No, Milord, what has happened?
That I have reflected in my order,
Mal.
that you will not be
Evicted,
evicted.
Milord. Or any
That-
coercive action may not be taken, Milord.
No,
Without the speaking order is passed, Milord. If the speaking order is passed, then they have the
that
power.
is already there, already there.
Mal,
There,
mal.
2 orders are there.
Mal.
So the extra copies.
Sure.
The petitioner is
I'll
directed to furnish requisite numbers of extra copies of the writ petition along with annexures to the London Council for the respondents within 2 days from the date of this order.
Milord, I'm sorry, Milord, one small correction. The earlier writ petitions disposal order is, Milord, 13/2/2026 and 17/2/2026. Two writ petitions were filed, Milord.
These directions are
Both the cases.
Both the two writ petitions were filed, Milord, in the earlier challenging the earlier eviction notices. And one is disposed on 13/2/2026 is at page 92, Milord. And another one is disposed on 17/2, Milord, 2026 is at page 104, Milord. Because, Milord, two groups were there, now both have, Milord, clubbed together in these petitions.
Instructions.
13.
mandated. 4th August. And in WPC number 882/2026 on 17/2/2026. वो अमिता मार्क कर देना, चेक करना पड़ेगा. I'll check it.
Malo.
Obliged. Obliged.
Obliged, Milord. Deeply obliged.
Item number.
May please, Your Lordship, it's not regarding the demolition of construction, Lordship. The second round of litigation, Lordship, prepared by the petitioner, Lordship. I'll let you file a writ petition, Lordship, bearing 3.
Where is the impugn order?
Simply on the last page, page number 43, Lordship. Lordship.
This is order under 337(3)
3, Lordship.
by Commissioner GMC.
GMC, Lordship.
Is there any appellate provision in GMC Act against this order? Against
Yes,
this order?
Already approached the appellate authority, but they did not enter, Lordship. After passing this order, Lordship.
They have not entertained.
Not, Lordship, because Lordship, not consider Lordship, because we approach on 4/3, Lordship, 4/7.
There is an appellate provision.
Appellate provision is there, but so far as the repetition is concerned, sir, nothing is there on that for that opinion will prefer.
Yes, that is my point.
Made statement.
Page 21, it is there, paragraph 21 is there. There is a statement that they preferred the appeal, but it was not accepted.
It
Page,
was
paragraph, page 18, paragraph 21. There is a provision that they appeared before it, but it was not accepted.
438.
438.
You take instructions. I'll issue notice.
Lordship, kindly come, Lordship, page number 38, Lordship, in earlier repetition, Lordship.
My lord, what happened, my lord? Let's see, lordship, there is an order to file a
Page number
reply, my lord. That reply was filed on 20, lordship will come to,
22.
lordship will come to paragraph, page 38, my lord. The order, last order, my lord. There is liberty was given to.
No, his grievance is you have not considered the
That's
documents.
the, my lord, that, it is also reflected in the impugned order. That's why, my lord, that appeal was filed on 22nd 6, my lord. In the impugned order was passed on 1/7, but it was said that the appeal, that reply has not been filed. In fact, the reply shows that the reply has been filed. That is not been considered.
Yeah, but file, Lordship, 22/6,
In
Lordship.
page number 40, the reply is there and the seal is also there. That this reply should have been considered. That's the case.
That is my
Only
prayer,
the-
Lordship, only prayer. Yes, Lord, yes. Because in the Lordship, impugned order is stated, Lordship, the petitioner.
Which para he mentions about?
Lordship will file the second paragraph, my lord, last line. But no reply has been filed till date.
Page number 43.
In the impugned order.
In the impugned order, page 43, my lord.
And where is the indication that he has filed?
Page number 38, Lordship, indication in last 5 pair, Lordship. That in view of the matter, this writ petition is disposed of allowing the petitioner to submit a reply in response to the notice dated 22/1/26.
Where have you filed the reply?
Yes, Lordship, 22, Lordship. Page number 40, Lordship. Page number 40, Lordship, we have filed application, Lordship, a reply 22/6/26. 22/6/26.
Yes.
Reply was filed, but it reflects that no reply was filed.
And regarding his submission that appeal was not accepted.
That is one aspect, my lord. But what is it better that lordship will was the impugned order and allow the petitioner to direct the commissioner to take into consideration of the reply dated 22/6 and pass a region order, because there is a direction for region order. That will suffice the entire issue, my lord. That will take into consideration of the reply.
21/2026, lordship will notice was issued with him. And in response to that notice, he was supposed to file his reply. He did not file the reply, approached the court, and court said, as he has not yet filed his reply, he should be given an opportunity to file his reply. And after his filing of reply, lordship may kindly see the direction at page 35, which is dated 19/6/2026. Lordship may kindly see the operative portion. He has been at page 39. 39, 38, 39. So he has been granted the opportunity to file his reply, directing the authority to take a decision, taking into account the reply to be filed by the petitioner. So it appears from the petition that on 22/6 he has filed his reply. But the impugned order was passed on 1/7. And therein it is mentioned that he has not filed any.
No. From where we can say that he has filed his reply?
Lordship may kindly come to page
Lord,
40.
page 40, Lordship, receipt could be, Lordship. My reply.
Yes. Okay.
So probably there is a gap between, concerned branch responses.
So
And that is why it was.
we'll allow the writ petition.
Yes, that is what I'm.
And then direct the commissioner passes speaking order as per the direction of the.
After considering his
The
reply.
reply. That's all.
Heard Mr.
Jiva.
Jaivanan. Learned counsel for the petitioner. Also Mr. S. Bora.
I appear for phone number 2, 3, and 4.
Waiting for
I've
it.
been for one lot.
No, also, what is your name?
P9 lots, as additional entry, preparing for the state.
P. Nayak.
Yes, Neway.
Heard Mr. P. Nayak, learned additional advocate general, appearing for respondent number
1.
1,
I am appearing for 2, 3, and 4.
as well as Mr. P. Bora.
Yes, Bora Lord.
Sorry, S. Bora, appearing for respondent number
2, 3,
2,
and
3, and 4. And what will happen to respondent number 5?
There is a private respondent, my lord. So, according to the petitioner, he initiated the complaint.
At this stage, lordship will take
Nothing.
a decision not to issue notice. On the basis of our argument, our submission. The Lordship has decided to dispose of this matter. There is no requirement to issue notice to respond. That's a question we have to look at. If you will participate in the proceeding.
This writ petition under Article 226 of the Constitution of India has been filed by the petitioner, namely Brikendra Basumatari, alias Brikendra Basumatari, impugning the order dated 1/7/2026 passed by the Commissioner, Gauhati Municipal Corporation, within bracket, respondent number 2.
Yes,
And
number 3 loss.
Respondent number 3 under section 337 within bracket 3 of the Gauhati Municipal Corporation Act 1971. Stop. The facts relevant for consideration of this writ petition in brief. I'll dictate it in chamber. The, reflecting your submissions and waiving the notice to private respondents.
No notice to respond by private respondent is necessary at this stage.
Yes.
Not to be disposed of. So only thing I am concerned about is if the decision is taken by the authority, till then only. If you protect, till that stage, not beyond that.
Till speaking order is passed.
Yes, as per the
Yes,
direction of the order dated 19.
Earlier writ petition.
Yes,
As that direction
earlier
was already there.
that direction was already there
Okay.
in paragraph number 8.
Okay. I'll dictate it in chamber. Writ petition is allowed.
Obviously.
Let's say disposed.
Disposed of.
May it please, your lordship. The petitioner here, my lord, is a company that brought the scrap from the Brahmaputra Valley Fertilizer Corporation. Lordship has seen that the fertilizer corporation will be going through an expansion, my lord. So the earlier infrastructures were demolished and the petitioner has brought all the scrap resulting from the demolition. My lords will find the relevant document at page 29. My lord. This is the sale letter issued by Brahmaputra Valley Fertilizer Corporation in the name of the petitioner, my lord. All the dismantled scrap will be taken by petitioner. From 36 to 42, page 36 to 42, lordships will find all the tax invoice. And the petitioner has paid around 114 crores for lifting of that scrap, my lord. Now the issue is, my lord, 3 trucks have first tried to take away the scrap, my lord. They were detained in Kokrajhar border, 2 trucks and 1 in Dhubri border. And they were asked to pay 22,000 as penalty. The petitioner, the truck drivers, my lord, they sought the exact grounds for that penalty and why it was detained. They were assured that the challan would be issued. But no challan was, my lord, issued. They still had to pay and the trucks were released, my lord. So my prayer is, my lord, that though if at all any violation has been done, it should be informed. The legal ground should be informed and penalty will be paid accordingly, my lord. But without any grounds, how can, my lord, the penalties be imposed?
What penalty?
Penalties of, my lord, 22,000 have been imposed on the trucks, but no written, my lord, communication or order as to why that penalty was issued has been given, my lord. So, my lord, the lawful process must be followed, and any penalty if resulting from a lawful violation will be paid, my lord. But at least the petitioner should know the. And my lord, the project is a critical project. Only when the scrap is taken away by the petitioner company, the Brahmaputra Valley Fertilizers corporations, my lord, expansion can take place. Now it will be stuck only because, my lord, the petitioner's trucks are being repeatedly detained. And, my lord, as per plan, about 1,000 trucks in 7 months, my lord, are going to pass through the border. All of them, my lord, will be carrying the invoices that will be issued by Brahmaputra Valley Fertilizer Corporation. But every time, my lord, if the trucks are detained without any, my lord, lawful ground or anything, and no challans are issued, my lord, then it becomes.
You have to pay money.
Yes, my lord.
22,000.
Yes, my lord. Per truck.
Against any receipt.
No receipt.
Any challan.
It was assured, but no receipt or challan was given, my lord.
Lordship, there is nothing to show in this petition whether who has taken the money, whom he has given the money.
That
Only
is why we are
allegation.
here.
So it is not the read court is not sitting here for dispose of all this matter. If there is some allegation, he has to inform the authority immediately. That someone has taken the police official, the transport official, they have access for money. And he has given the money. And my lord is well aware, giving money and taking money is also the same kind of crime, my lord. And there is nothing to show that the police officials or the transport official has taken money from the petitioner association company. The lordship here, if such things that happens in the border area, he should have informed the authority, informed the police authority. Police person also there.
My
He
lord,
did not do so. He straightly
Yes.
came
Who
before.
is taking money from?
Yes.
My lord, may see page 43, my lord. We have given our detailed representation to the Director General of Police. And, my lord,
It is on July 1st,
Yes.
he has written. But he has said in the petition the money has been taken by some
Yes,
person,
because it was, my lord,
government officials. On July 1st only, he has written to the DGP. And straight away he came to the honorable court.
because, my lord, it was assured at that time that challan will be issued. They took our documents, took copies of our documents.
Now, where is your representation?
Representation is
Page
page 43, my lord.
Now, who is collecting? Have you mentioned?
Yes, my lord.
It is
My lord may
clear.
see a table. I have given it in my pleading.
Who has collected?
Page 20, my lord.
No,
This is the details.
who is collecting? Whom you are alleging?
Police authorities, my lord. Page 20, I have, my lord, specified when it was done, which authorities.
Okay, you take instruction, file.
Lordship, I am appearing for transport department. My senior colleague is appearing for the police. He will
take the instructions.
Otherwise, my lord may dismiss this petition. That is because there is no impugn order, nothing to show that someone is taking money. And he has given the money.
That is why, my lord, we are here. If
Giving money is
anything was,
Then appropriate forum, he may approach lordship. This
which
honorable
form, my
court-
lord? If no challan is issued,
It is a matter of fact, he may approach the civil court.
my lord, 301 article, my lord, says there is free trade, my lord, right to free trade.
Okay, heard. Well, Mr. Aibo Thakur, Lanet. Counsel for the petitioner. Also, Mr. S.S. Roy, Lanet Government Counsel appearing for
128.
respondent number 128.
Lordship, I am MD Bora, Standing Counsel Transport for respondent number 9.
Also, Miss L.V. Bora,
MD Bora.
M.D.
MD Bora.
M.D. Bora,
Standing Counsel Transport Department.
Lanet Standing Counsel Transport Department
For respondent number 9.
appearing for respondent number 9. This writ petition under Article 226 of the Constitution of India has been filed by the petitioners, by the petitioner, namely HR Commercial Private Limited. Which is a private limited company and is and has purchased the movable assets and scraps resulting from dismantling and disposal of Namrup 1 and Namrup 2 plants of Brahmaputra Valley Fertilizer Corporation. Within bracket, respondent number 10. In pursuant to an e-auction conducted by Metal Scrap Trade Corporation Limited. Stop. It is alleged by the petitioner that after purchase of this aforementioned scraps, the petitioner company has to transport it out by loading the scraps on trucks. However, the trucks are illegally detained in Kokrajhar region, and a coercive collection of rupees 22,000 per truck has been taken by who? Who is collecting? Where is the allegation?
Para 20, my lord. Page 20, my lord, page 20. 2 trucks by police authorities in Kokrajhar district and 1 in Dhubri district, my lord.
Detained by police authority in Kokrajhar district, as well as 1 truck has been detained by police authority in Dhubri district on 30/6/2026. And to that effect, the petitioner has also submitted a representation on 30/6/2026 to the Director General of Police, Assam. However, the said representation has not been attended to by the authority. Learned Government Council, Mr. S.S. Roy, submitted that some time may be granted so that he may obtain necessary instructions in this regard. And if necessary, he may file an affidavit in opposition. On the other hand, Learned Standing Council, Transport Department raised the question of maintainability of the present writ petition, as she submits that the petitioner has not clearly indicated as to who is extorting money from the trucks. And she also submits that the petitioners have other avenues for redressal of his grievance, and without resorting or exhausting such avenues, he has directly approached the writ court. Stop. I have considered the submission. Let the notice be issued. Since
For respondent number 10, the petitioner have to take steps.
Okay. Since for respondent number 1 to 9, Learned Government Council / Standing Council, Transport Department has already appeared, no formal steps for issuance of notice to the said respondents is to be taken. However, the petitioner is directed to furnish requisite numbers of extra copies of the writ petition as well as annexures to the Learned Councils. As regards respondent number 10 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by speed post as well as by usual mode, returnable within 7 days from the date of this order, returnable on 5th of August, list accordingly.
Deeply obliged,
Obliged.
Lordship. Deeply obliged.
Finish. Time. Huh? Time is over.
May I please, your lordship, item number 51, I beg to withdraw the petition as I have the instruction to withdraw the 51, item number 51. Upon instruction, lordship.
51. What is your name?
Yes, Ali, lordship.
Heard Mr. S. Ali, learned counsel for the petitioner, who submits that he has been instructed by the petitioner to withdraw the instant bail application. Also, Mr. B. Sharma, learned additional public prosecutor. The prayer is allowed. This bail application is dismissed on withdrawal.
I'm obliged.
So for item number 47, my lord, I am on previous bail, my lord. My imprisonment is for only for 3 months, my lord. So next date is fixed, my lord. Till that date, my lord, I am just allowed to go on previous bail. So
The
there
next date is till 17th.
17, man. So that's why
So let this case be listed on 13th.
13 months, yes. Deeply obliged.
47.
47, man.
Due to paucity of time, this matter could not be taken up. Let this matter be listed on 13th.
Lost.
Lordship, item number 13 in the morning. I was behind the bar only on the basis of a statement of a co-accused, from whom 6 grams of heroin was recovered, Lordship.
Item number
13.
13. What happened?
I am for 50.
Next.
Can it be taken on 9th or
On 9th.
maybe it is hardly for 1 minute.
Reopening,
9th or 13th?
9th, Lordship. 9th? 9th.
9th, you will need permission of the concerned judge
Lordship.
who is sitting. I don't know who will be sitting.
13.
On 9th, you can
Mention, I have to mention.
mention again
Lordship.
by sending emails.
Lordship. I have another item on 53. Lordship, CD has not come. That may be kindly fixed on 43. I was behind the bar for last 68 days.
53.
53 Lord.
53.
The allegation that হত্যা করার উদ্দেশ্যে তার বড় 52 লাখের খুব মার।
Due to paucity of time, this matter could not be taken up. Let this matter
14th Lordship, as per-
on 14th of July.
Lordship, item number 49, Lordship. Lordship, CD is there, Lordship. The matter may be fixed on 9, Lordship. 49. Because, Lordship, I'm behind a bar since 38 days, Lordship. I was arrested on 31/5. Lordship, 3 petitioners are there. Already CD is there, Lordship.
No. Other matters will be left over. For if you want fixing your case to be before vacation court, next vacation court, day after tomorrow,
But
then you have to file an email.
Yes, Your Lordship.
Then for these cases will be shown as leftover. No orders will be passed. If you file an email, it will be again listed on 9 on day after tomorrow.
Item 56, my lord. That, my lord, it's the allegation is abetment, my lord, to commit suicide, but apparently in the FIR, my lord.
No,
there is-
no. What is your prayer?
My prayer, my lord, can it be on 13th, my lord, because I'm not on interim, I'm a teacher, my lord, very young.
56, 13. Paucity of time. Let it be listed again on 13.
My lord.
May I please, Case that is here, matter 57, and all the co-accused have been granted pre-arrest.
Which item?
57.
57,
Case
13.
that is here, madam.
57, 13.
Item 52, my lord, also on 13 month.
50,
52 month.
52, 13.
My lord.
Item number 46, my lord. My item was next item, my lord. Can be on 14, my lord. On reopening,
46 on 14.
14. Obliged.
Item number 48, Lordship. In this case, Lordship, the PCR was called for Lordship. But Lordship, at the accused is in custody, Lordship, about.
What is your pair?
Lordship 13. Otherwise, Lordship, the FIR, as per the FIR and what there is nothing, Lordship.
Minus can copy not.
Can it be
minus
63
that
days in
are
custody?
called for.
14.
It will not come minus.
Come from Gauhati, Lordship, but otherwise two dates already gone, Lordship. But apparently, Lordship, the FIR is totally different.
Don't submit on merit on. You only mention about dates.
That's for a moment, Lordship. I will produce the certified copy, Lordship, but only fixed for evidence on 9, Lordship, 9 July, Lordship. So otherwise, there is everything is with me, Lordship.
What is your prayer?
Lordship, it can be 13, Lordship.
Okay, I'll fix it on 13.
Obliged, Lordship. Obliged.
48, 13. Yeah, yes.
My lord, as regards item number 54, my lord. Is there is available, my lord. So lordship may
Well,
fix any date after reopening, my lord, as your
You
lordship
suggested it.
My lord,
You suggested it.
either 14th or
14, 13,
16.
54, 14.
14th. Oh, obliged, lordship.
CD maybe you can. Item 58, my lord. Maybe listed on 17, my lord.
58, 17.
Obliged.